Clerks. It's unfortunate that they're not afforded an attorney at that stage, but they have to teach themselves.
So I was really, truly impressed and dismayed that he also shared that 7 of his fellow inmates were also exonerated of their guilty verdicts later on. And the presenter also talked about the state of Nebraska having a Supreme Court case, very similar individual who was seeking that gateway to innocence, that opportunity to have his case heard again. But they talked about there's impediment in the state of Nebraska on the policy itself, that we need I guess the Supreme Court judges in Nebraska said that there has to be some type of legislative policy enacted for the state of Nebraska to permit those to access what they call the gateway of innocence, or gateway to innocence.
Yeah, so this is one of those circumstances that I know we've talked about it in the legislature this year on other subjects where the court comes to some finding or comes to a ruling, and then in their opinion will sometimes include something to the effect of, but we're doing that because we can't do anything else. It would have to be up to the legislature to change this. And so, one of the things they were talking about in that Nebraska case is this person argued to the Nebraska Supreme Court, I believe, this concept of gateway innocence. And again, I don't want to get too in the weeds about it, but it's this standard that's been adopted, I think, by
1 minute.
Thank you, Mr. President. Some courts where the Nebraska Supreme Court said we cannot effectively proceed under that legal theory because the legislature doesn't allow it, because our current system and structure of post-conviction relief does not allow that avenue to ultimately get your case reheard or get your case back before the courts. And so they threw the ball into our court and they said it's up to you all to determine whether or not this gateway innocence is something that can and should be ultimately, I think, adopted. And that's part of what we're going to be talking about in our interim study, is that this isn't about who's bringing the case. It's not about right or wrong. It's ultimately just about creating the framework within which an actually innocent person can get their case heard before a court.
Thank you, Senator Dungan. It was an outstanding program, and I look forward to embracing more criminal justice reforms that allow people that are wrongfully sentenced to find a pathway to freedom. Thank you, Mr. President.
Thank you, Senators Raybould and Dungan. Senator Day, you're recognized to speak.
Thank you, Mr. Lieutenant Governor. I would like to yield my time to Senator John Kavanaugh, if he wishes.
Senator John Kavanaugh, 4 minutes, 50 seconds.
Thank you, Mr. President. And so I got a lot of thoughts. You can tell this is like I said, it's one of my passion projects. So Senator Lowe was over here talking about digitizing courts, and I want to be clear. I do really like the technology aspect of our courts. So just right now, I'm just trying to pull up the Nebraska Supreme Court case that Senator Dungan was talking about. It's one that I think they decided in September of 2020, if I remember right. But you can go on their website. You can pull up basically any cases of the Supreme Court opinions. They have Court of Appeals opinions as well. You can read the advance sheets for those cases, and it's great. They come out, they email them, every Friday, and so you can stay informed. You can look up things, old cases. So that digitization of all those records is fantastic. We have an online justice system that has digital filings now, so you can file, a request for hearing or other things from an entry of appearance from your laptop in your office. You don't have to go. You used to have to go up to the window. You have to fill out a carbon copy, go up to the window to ask to have your client brought in, and if you were, say, in Omaha and you had an office in West Omaha, you'd need to go downtown to file it. And if you got close to the end of the day, maybe your client would not get to go into court tomorrow. So you can do it on a computer. Obviously, that increases access to justice, and those things are fantastic. Making it all work more efficiently. Then, of course, it's online. People can see it. Prosecutor can see it, or whatever the other opposing party can see it. Courts can see it. And of course, then you eliminate what is one of my bigger problems, which is legibility of my handwriting. So by having it typed on a computer, that improves all of those sorts of things, makes the whole system work more efficiently. And then, of course, these record keeping makes it go a little bit better for appeals and things like that, as Senator Dungan was just sort of alluding to. So I was trying to look something. I'm trying to remember exactly what it was that Senator Raybould had mentioned that made me think of something else that we talked about at the Innocence Project today. But I'm sure I will come back to me as I'm talking about the other things I was going to talk about. I've talked about this dehumanization, and sometimes we say these things and people are like, oh, talked about this a lot. I mean, it's sort of in the academic, literal sense of dehumanizing, not that we're, not in the, I guess, pejorative sense, though it is not a good thing, right? It's not good to dehumanize people, but it's certain things can have a dehumanizing effect, which it's basically a disassociation, disconnection. You're not, the judge and the prosecutor and you're not connecting on a human level in the same way you do when you're in person. And so that is a concern. And so we've had in our court system a sort of a move forward. We had this opportunity, kind of a proof of concept, a pilot program forced on us with the pandemic that allowed us to get a lot more, technology into the courtrooms a lot faster and a lot out of necessity, and a lot more trial and error in those hearings out of necessity. And so that has allowed us to move the ball forward on those sorts of things. But what I'm cautioning, I guess, is that we don't overlearn that lesson. Say, okay, this is great. We can do it all now. We can do everything remotely. We want to make sure, proceed with caution, and say, we don't have to do everything this way. We don't want to force people. And what I'm saying is,
1 minute.
Thank you, Mr. President. The court should not change its rules, and the state should not change its law to shift the burden to the defendant to prove that they need a hearing in person. It should stay their right to assert and say, they can waive it and say, in the interest of efficiency, I would like to get this hearing over with. I'd like to not have to come back from McCook. I'd like to not have to go from be transferred from this county to that county. I would like to just do it by a Zoom. That can be their right. They can waive that. But what I'm saying is it has to remain their right and not in the interest of efficiency force that would say that it's up to the discretion of the court alone to make that decision. Because the courts, though I have great respect for a number of judges who I've worked with, they do make some decisions in the interest of expediency and efficiency when it comes to some things like that. They say, well, I've only got...
That's your time.
Thank you, Mr. President.
Thank you, Senator Kavanaugh. Senator Dungan, you're recognized to speak.
Thank you, Mr. President. And colleagues, I got so excited about talking about the event that we had earlier today that I actually neglected to get into what I was originally going to talk about when I first stood on this. And so I do rise generally in favor of AM 1692, but I do have, I think, some thoughts about it that I want to make sure we keep in mind as we proceed. So for those who are actually paying attention, either at home or in here with regards to which amendment we're on, this is AM 1692, which seeks to add, as Senator, I think, John Kavanaugh talked about earlier, the addition of virtual to the E&R amendments when it comes to an allocation of money or an appropriation of money for interpreters. So my reading of this is that it is making sure that here on page 18, line 2, the $500,000 in federal funds for the purposes of supporting in-person interpreting in rural areas and legal communication access now will also include virtual. So I am generally supportive of access to justice measures, right? When we talk about access to justice, we have an entire group of the Supreme Court that works on access to justice, and that generally means ensuring that individuals who either are indigent or maybe aren't native English speakers, whatever it is, have access to our justice system. And one of the things that's key for that, which has been talked about, I think, a little bit now here tonight, is ensuring that there is the technological access as well, right? So Zoom, being able to call in when they need to, and then specifically here, being able to access virtual court interpreters. And this is interpretation, not translation. The Supreme Court wanted to make sure that I made that clear the last time we talked about that. So this is not doing documents. This is literally interpreting spoken word. My hesitation, and I just want to make this clear, is I have worked with both in-person interpreters and virtual interpreters. And despite the breadth of knowledge that those interpreters have, no matter how amazing they are, it is different. When you are working with an individual who is an interpreter over Zoom, for example, there is that added layer of difficulty. Not because of any thing the interpreter's done wrong, but the technological aspect is problematic. And when I first started working in juvenile court a number of years ago, there was a push to implement more technology with regard to detention hearings. So let's say juvenile gets arrested and then appears before the juvenile court for a detention hearing. There was a push to do those detention hearings digitally via Skype, via Zoom, whatever it was back then. And the hesitation that we had was that that lack of human contact is going to create a different kind of ruling by the court, and B, it's actually going to potentially impede the ability of the attorney to properly interact with and talk to a client. So I want to put this another way. During the pandemic, we obviously went digital with a lot of court. And when you are in a digital courtroom, it's you, your client, the county attorney, the judge, the court reporter, the bailiff, you all have an individual window that's up there. And if you have an interpreter, the interpreter has another window. So you say something, you pause, the interpreter interprets, client listens, client talks, interpreter listens, interpreter talks back. So you have that sort of delay. it does become digitally problematic and difficult to get those things done the same way that you would if you have somebody in person. Now, obviously, the pandemic and other situations like that necessitate the use of virtual interpreters, and I'm absolutely in favor of allocating money for the use of
1 minute.
Thank you, Mr. President, digital interpretation services. But what I want to be very cautious of is getting away from in-person services when they are available and when they are accessible. And if we start to find ourselves in a situation where clients and attorneys are forced into digital hearings or are forced into utilizing digital interpreter services, it's going to be very problematic, only because it can impede the actual representation of that client. And I want to be very clear, those clients have a constitutional right to zealous and adequate counsel. So again, I'm generally in favor of AM 1692. I really appreciate the Appropriations Committee working on this. I understand they've worked really hard with me to continue to fund our court interpreters, and I'm appreciative of that. But as we move forward, I think we have to be cautious with regards to further use of virtual or digital interpreters. Thank you, Mr. President.
Thank you, Senator Dungan. Senator Day, you're recognized to speak.
Thank you, Mr. President. I would like to yield my time to Senator John Kavanaugh if he wishes.
Senator John Kavanaugh, that is 4 minutes and 44 seconds.
Thank you, Mr. President. Thank you, Senator Day. I appreciate Senator Dungan's perspective as well. And this is, I think it's a really important part of this conversation. And again, I do agree. I appreciate the Appropriations Committee allowing or providing for the fact that we can do in-person or virtual this translation services. I do appreciate Senator Dungan recentering the conversation on that, because sometimes we get excited about talking about a topic and we start going further afield from that. I say that because when I started talking about this, kind of set the stage for a lot of you, talking about just how courts kind of came to this the digital frontier in our courtrooms, and then how, we've pushed it further. And one of the things try to get to what my concerns are, which is we saw during the pandemic that, we were pushing court hearings further and further down the road, push out trials, push out sentencings. I think we went almost a year without trials, and then push out sentencings, push out evidentiary hearings, push out competency hearings, push out all these hearings because we didn't have in courtroom meetings. And some of those things just really need to be done in person, as I've talked about earlier, because of the dehumanization effect and the being ability to appraise and judge somebody's honesty, veracity, all those things that a finder of fact needs to make a determination about when they're weighing evidence. But I know of examples of times where judges said, we need to get this case moving. You can have this hearing on Zoom next week, or you can have it in, 2 months or something like that. That then it puts pressure on the defendant to say, rather than have a hearing in the way that their attorney advises them is the best, in the way that they want their case to be presented, it's forcing them to have a hearing in a way that is, maybe less, that's going to yield a less favorable result for them. And, then they go through all this appeal process that Senator Dungan was talking about. If they ultimately are found guilty and they go and have an appeal, and the weight of the evidence is going to be measured basically by given deference to the judge for their assessment. So if they found the witness credible in whatever fashion that they had heard that evidence, that's going to stand. The judge's opinion of that's going to stand because they were the one that was there to observe it, as opposed to reading it on the paper. Easier to appraise their veracity in person than it is on paper. So if we start, the problem is you force somebody to agree to either sit in jail for 2 more months before they can have this hearing that they think may get them out, or have it on Zoom. They maybe waive their right to have it in person, then they end up having on Zoom, doesn't go the way that they hoped it would. They end up getting convicted. They end up going to prison, but then they do not have an appealable issue there that has, basically forfeit a right to how they're going to have their hearing. They didn't get to have their case presented the way they wanted it to. And so that's one kind of microcosm of the risk we have where we over implement digital or whatever, these types of hearings.
1 minute.
Thank you, Mr. President. And so going down this path of this becomes problematic, of course, it is useful. Like I said, the filings, you can file probably from vacation. You can file, you take your laptop with you and you go to whatever, Mexico, I guess, you need to file something for a hearing. You can do that kind of work from there. So that, helps lawyers, helps the courts, helps clients get more access to the courts. It improves cost. And in theory, you could have a Zoom hearing. You could have your lawyer be from somewhere else, or could be, if your lawyer's out of town, doesn't mean you can't have a hearing, right? As long as the defendant agrees to that. So it does add those extra benefits to the opportunities for someone to get into court faster and not have to sit in jail if they are asking for a bond review. And you can ask for a bond review on Zoom. You can say, I want a bond review tomorrow.
That's your time,
Thank you,
Senator.
Mr. President.
Thank you, Senator Kavanaugh. Senator Walls, you're recognized to speak.
Thank you, Mr. President. And I have to apologize. I was off talking to somebody when Senator Kavanaugh was speaking. I wasn't sure if you had already talked about how digital services affect rural areas compared to urban areas. I have both in my district. And again, I apologize, but if you could talk about that, if you haven't already, I'd appreciate it. If I could yield you some time.
Senator Kavanaugh, you have 4 minutes, 30 seconds.
Thank you, Mr. President. Thank you, Senator Walls. I would love to talk about that. So the state of Nebraska is divided into different judicial districts, and different districts can set kind of court-specific rules. And so we have, in Douglas County, we call it the 4th Judicial District. And that's we have one district court, separate juvenile court, separate county court, but it's all the 4th Judicial District. Then you have, I don't know which judicial district Fremont is in, but you would encompass a few other counties. And so you might have separate rules that are established by your judicial district. And so not everything is going to apply across the board because these different districts in the Supreme Court can promulgate rules for their district. But Douglas County, we've kept it pretty tight in terms of what our court rules are for these virtual hearings, and I would assume Lancaster is similarly. But one of the reasons for that is we are more compact. Everybody, in Douglas County, for the most part, our jail is walking distance from our courthouse. It's 2 blocks, I think. And they drive people back and forth, but that's all pretty compact there. And Douglas County itself is actually a relatively compact county. So there's not as much of a need for, people having to come great distances. But in a district like yours, or maybe, a couple of the other even bigger districts, or where the judicial districts get bigger and bigger, there is a lot more conversation about this move towards doing almost everything on digital. And like I said, there is the possibility of a benefit for everybody. The parties, I keep talking about criminal court, but you can have civil court too, where the parties, both plaintiff and defendant, or the state and the defendant, would agree that rather than have everybody drive into Fremont, they can Zoom in from wherever it is they are. They'll save gas, they'll save time. The court doesn't have to, set up the court and all that kind of stuff. They don't have to find as much time because the judge just is sitting at their desk, and they just hit Zoom, and then they could hit to the next Zoom hearing while people are in the room. So there's a lot of those sort of efficiencies, and there is a desire to do that, I think, in greater Nebraska. There's also the added complexity, burden, whatever you want to call it, the fact that in our rural counties, we are having a shortage of lawyers. And so this is another thing where, I guess playing devil's advocate to my own criticisms, we'll say, where virtual court can be a benefit, because you could have a lawyer in Douglas County, Lancaster County, where there are a lot of lawyers. They can zoom into a hearing in Arthur County, where there might not be any lawyers, right? And so all these rural counties that have either very few lawyers or getting fewer and fewer lawyers as people retire, we might have the opportunity to continue to serve those communities from the legal communities of our cities, which, saves money for travel time, of course, because if the court-appointed lawyers driving out from Lincoln to Arthur County, they might pay them for mileage. But saving
1 minute.
Thank you, Mr. President. So increasing access to the courts for folks in rural communities, increasing access to great, competent, qualified legal services. And so those sorts of things, making it so we have an opportunity to have more legal services available to folks in greater Nebraska. So there is certainly that benefit, but I would always caveat that with and say that is a benefit to make sure that there are lawyers available, but the ability to ask for the hearing to be done on Zoom or to not object to it. There's a difference. There's a distinction between objecting to a hearing being on Zoom and affirmatively waiving right to have it in person. Should always rest with the defendant in a criminal case or the defendant in a civil case. The person whose rights are at risk, they should always have, that should be their option to waive it being a in-person hearing, because they may get the benefit from having a lawyer zoom in.
Time,
Thank you, Mr. President. Thank you.
Thank you, Senator Kavanaugh. Senator Vargas, you're recognized to speak.
Thank you very much. Colleagues, I was going to talk a little bit more about some of the different items that are in here to both provide a little better education. For those that have been following along, not only do we see some of the bigger items, but on page 76, this just goes to show you exactly how detailed we get into the appropriations process when we're doing these adjustments. You're going to see a detailed list of every item that we did that was an adjustment, down to additional funds for the Secretary of State, for PSL, different education for Education Department for Kronos payroll rate increases, for retiree payouts in the education system, to increases for PSL, or the ability to hire more staff within the auditor's office. One that I did not get to actually talk about the previous time was the funding that we included in these one-time funds adjustments for the Department of Transportation funding. So this is essentially, we were transferring these state funds to be able to leverage a federal match as a result of the Infrastructure Investment and Jobs Act. It's about $150 million in cash funds that we transferred in one times, which was required as a 25% match of the total funding. So we are dealing with everything from a $50,000 authority increase to be able to hire additional staff member, all the way to $150 million in cash fund transfers and from the DOT to leverage federal funds. What I lovingly say is this is truly, at least our committee is sort of an island of misfit legislators where we're coming together and trying to do very minute work and to really big sweeping investments and one-time things into our state. I'm really proud of the committee that we work on things. We win and lose in the committee. It's not always perfect. And I've said this before, we have so many bills that we are either have introduced and issues that we work on in collaboration with different agencies to address things, even issues that we were just taking up today. We do this, and it is an iterative, very, very intentional process. I'm just really lucky to be a part of this appropriations committee and the work that we've done the last 6 going on 7 years. And the reason I'm also sharing this to you is because many of us are going to be off the committee here in the next year and a half. And when we're off the committee, the things that I'm saying on the mic may seem extremely trivial to people because they're either uneducated about it or don't know. But this being sometimes your first budget process, there will be new people either elected or in the body that choose to be on the appropriations committee. And we get really into the details, and it requires a thoughtful lie. It requires somebody that is willing to have really tough conversations on small amounts of funding to large amounts of money. We've been debating in committee when we were increasing the authority for an agency that's cash funded to the tune of $1,000. We were debating on whether or not we can increase technology and whether or not some people's computers should be new, or if they can handle an additional year of utilizing the same computers that they have. We've had this conversation about new cars, for used cars that are being continually worn in within Game and Parks, and whether or not we should give them more authority to buy new cars. And I remember conversations in the past several years, even with Senator Wishart, where we said, my car has more mileage than many of the cars that they are talking about in the requests. This is all to say that this is an important educational process. This isn't the mainline budget bill. These are the adjustments we're making. But I also think it's really important that the public and my colleagues understand the very important, significant changes we're making to our previous budget and the relationships we have with agencies, the tremendous amount of work that our fiscal analysts do to ensure we are responding to the executive branch's needs and the agency's needs. This has been an amazing effort on the part of all the staff and the Appropriations Committee. And I ask for your continued support on not only this amendment and the underlying bill, but all of our budget bills as we move forward towards the end of this session. Thank you very much.
Thank you, Senator Vargas. Senator Day, you're recognized to speak. This is your last time on the amendment.
Thank you, Mr. President. I would like to yield my time to Senator John Kavanaugh.
Senator John Kavanaugh, you have 4 minutes and 55 seconds.
Thank you, Mr. President. And so I appreciate folks paying attention and being interested in this topic. And just so we're clarifying, I support AM 1692. I appreciate Senator Clements' attempt here, and I'm not intending to try and cause a problem for this particular amendment. I just thought this was a good opportunity to have a broader conversation about our implementation of technology in our justice system. And I admittedly, I don't think this amendment only applies to justice system. I think this applies to, I'm trying to pull it up right here. So this is for, the funds are for the Commission for the Deaf and Hard of Hearing, and then we're giving this includes an amount shown for this program for FY 22-23, $500,000 on federal funds for the purpose of supporting in-person, and then Senator Clements' amendment would be, or virtual interpreting in rural areas, and legal communication access. So it's basically saying that it's adding that the money can be used for in-person or virtual interpreting. So it's just adding that to it, not mandating it, not requiring that we move to virtual entirely or do anything along those lines. But the reason I wanted to have this conversation is because I of course think we should make these sorts of things available, because when it comes to interpretation, being for the deaf or the hard of hearing in this particular case, but we want to make sure that we have those resources available for people, even in places where there might not be readily available interpreter, or it might be hard to get one there. And so I think this is a good move, good step in that right direction. But when we start down this path of adopting technology and we find things are great and they work really well, I think we need to make sure that we are deliberative about which things exactly we apply technology to, and where we put the ability to decide which things should be done in person, which things should be done digitally. So I would say if a deaf or hard of hearing person only wants to deal with an interpreter in person, that should be at their discretion. They shouldn't be forced to use a virtual interpreter, but that's not what we're addressing here. But I'm talking about in the criminal justice system, in particular in the courts, we need to make sure that we are not getting to a point where the discretion is taken away from the individual. And so here's an example. So as I told Senator Walz, we have the judicial districts in the state of Nebraska. And so for Senator Walz, you're in Judicial District 6, which I would tell you goes all the way up to maybe, is that Knox County? Goes up past Thurston So kind of curves around on the Missouri River there. So kind of a really big county, a big judicial district. And so, of course, there may be a greater interest in that. But then there's Judicial District 1, which is south of Lincoln. So Lincoln is Judicial District 3. You got Judicial District 1, which is basically everything. Senator Brandt's district, Senator Dorn's district, and it looks like maybe Senator Slama's district. So Judicial District 1, as an example, had a proposal for a protocol for virtual meetings. Virtual meetings will be available for non-testimonial proceedings based upon the sole discretion of each county and district judge within his or her courtroom. Requests to participate in virtual proceedings shall be made by filing a request with the clerk at least 3 business days in advance of the hearing, each party appearing via, and they cross out WebEx and put video. So they were trying to genericize WebEx here.
1 minute.
Will need to be logged 5 minutes in advance. So what I'm talking about there is that this is the determination of whether to do it in person or on WebEx or as video is solely at the discretion of the judge. And so that's the thing I'm concerned about becoming a broader adoption. So this is non-testimonial proceedings. So not a motion to suppress, not a trial, not necessarily sentencing. So this is a hearing where there's not going to be any evidence putting on. It's probably like maybe a bond hearing or something like that. Could be by a video conference. And so what I'm saying is that the problem in that situation, though, this is, even though it's non-testimonial, is that it's at the sole discretion of the judge. And it may have to do with the liberty, so determining the liberty, the freedom of the defendant. And the defendant might want to have that hearing in person. And so I'm saying we don't, in the interest of efficiency, we are creating a structure where the judge gets to decide whether or not the person is going to be at time. Thank you, Mr. President.
Senator Duncan, you're recognized to speak.
Thank you, Mr. President. Colleagues, I still again rise generally in favor of 1692. And just to pick up with where my roommate John Kavanaugh left off, the main concern that I have when we start talking about the digitization of courts is that we are going to ultimately accidentally end up depriving clients with the ability to interact with their attorneys in an effective manner. And again, I think the goal of access to justice is laudable and one that we should all work towards. But what we need in that access to justice conversation is the ability to make those decisions based on the nuance that goes into an individual court case, rather than unilaterally decide that that's how something is going to end up, or not allow defendants or their attorneys the opportunity to potentially object, or at least have their voices heard with regards to that decision. This lends itself to a circumstance that this reminds me of a circumstance that I found myself in very early on in my legal career, where I was representing a juvenile who was not from Nebraska and in fact was not from America, and spoke Romanian. And believe it or not, we don't have a lot of Romanian interpreters in the state of Nebraska, at least not that were available at that time. And we had a hearing that, for all intents and purposes, I genuinely think probably would have taken maybe 3 or 4 hours. But we did not have access to an interpreter in the courtroom. And what makes this even more complicated is because it's a juvenile case, the parents are allowed to be there too. And the parents only spoke, or the mom only spoke Romanian. And to further complicate the issue, when that kind of circumstance presents itself, you need multiple interpreters. And the reason that you need multiple interpreters, A, is if any case is going to take over a certain period of time, they have to switch out because they essentially get tired. Doing simultaneous interpretation about high-brow legal concepts can be actually very taxing. And B, there needs to be an interpreter for the court, and there needs to be a separate interpreter, generally, it's best practice, between the client and their attorney, so that way you can keep confidentiality. So we found ourselves in a situation representing juveniles, or a juvenile, it was a joint hearing, so there were 2 of them there, who spoke Romanian, and mom who spoke Romanian, and her the other mother who spoke Romanian, and we didn't have an interpreter that was available. So what we ultimately had to do was got together with the county attorney, got together with the court, and we found some Romanian interpreters on the phone. And believe it or not, trying to interpret a case via phone during this really intensive transfer hearing is what it was. They were trying to transfer this case from juvenile to adult court, is complicated. And despite, I think, the best efforts of everybody involved, and despite the best efforts of the interpreter, who was very talented, I don't know where they were physically located to this day, it took a very long time. And this hearing that ultimately I think would have taken, again, a few hours, was stretched out between 2 whole days. And I had never had a juvenile hearing take longer than a day. I'm looking at the lieutenant governor up there, who I know has practiced before in court, and a hearing in juvenile court taking 2 days because of interpreter issues, which were generally us pausing and them saying, huh? What? Can you please repeat that? Was arduous. Now, again, I don't think anybody is suggesting that we go completely to a digital system, and I don't think anybody is suggesting that we mandate that. But when we talk about this, I just want to make sure when we're bringing amendments to bills that are not coming out of judiciary, thank you, Mr. President, that have not probably had the testimony from practicing attorneys who have worked on this, that we're being cautious and careful. I know in the past there have been bills that have been brought that would allow wide discretion for these things to be done, these hearings to be done digitally, that did not have any language that allowed for perhaps an objection, or that didn't allow for a way to push back. And I think that the reason those ultimately did not move forward is there was an agreement, or at least an understanding at how problematic that could be. So again, I urge your vote on 1692. I think we should vote green on this because we have to make sure our interpreters do receive that funding if they're digital or in person in rural areas. But anytime we're having a conversation about the digitization of court, please keep in mind it's incredibly important that we do everything we can to ensure that there is autonomy in making that decision, and that nobody's forced into a situation where their rights are deprived by virtue of not having access to counsel that is zealous and generally going to do the best job they possibly could do. Thank you, Mr. President.
Thank you, Senator Duncan. Senator Raybold, you're recognized to speak.
Thank you, Mr. President. I too want to speak in support of AM 1692, particularly on the necessity of having interpreters. They are essential to our judicial system at this point in time. My husband was a former certified court interpreter, and I can tell you that it is a very difficult exam to take and very challenging. And of course, being a certified court interpreter is quite stressful to be able to simultaneously translate in the hearings. But I know it's a necessity. It's part of our diverse Nebraska. And I can tell you, I've traveled all around our state, and I've been in several courtrooms as well, and watched other interpreters just perform flawlessly in challenging times and trying to minimize the court's time as well. So it is an essential thing. The other thing that I know that Senator Duncan spoke about was video conferencing for our judicial system. And it is so essential. And I really think the rural communities have been using this a lot sooner than some of the urban areas. And I can speak of my time as a county commissioner, and I know certainly our lieutenant governor was there as well when we built a new county jail offsite, on West O Street, and it became a real challenge. We thought that the judges would embrace video conferencing for video arraignments, but that was not the case. So the initial, once the new jail was built, we did have to transport the inmates to and from the courthouse for the arraignments. But one brave judge volunteered to be the guinea pig, and little by little, we won over all the other judges on how important it is and how it saves not only the court's time in seeing the inmates and getting through a backlog of arraignments. It really reduced the risk to our state patrol, as they're the ones that would have to transport the inmates to and from the county jail to the courthouse. So it would save them time, fuel, and also was a big safety factor for that. And the exciting thing is it really took off. A lot of the judges really embraced the idea of having video conferencing video arraignments, and it became the most sought after request. Can you convert my courtroom into being able to do this as well? And I can tell you, certainly, and you all lived through the pandemic here, in the city of Lincoln, we were able to continue our meetings so that government stayed open the entire time. And we didn't miss a beat. And, you know, we were very fortunate with video conferencing, as well as the schools in Lincoln and Lancaster County were able to stay open, and kids were able to go to school via Zoom meetings and so on, and how fundamentally important it is. And I think because of the pandemic, we realize that this is an excellent way of taking care of business, working with our judiciary system, making sure that our kids get educated, and just going back to how fundamentally important it is to keep funding these items for the efficiency and efficacy of getting all types of work accomplished. Thank you, Mr. President.
Thank you, Senator Raybold. Seeing no one else in the queue, Senator Clemens, you're recognized to close on the amendment and waive. Members, the question is, call the House. There's been a request to place the House under call. The question is, shall the House go under call? All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
16 ayes, 2 nays, place House under call.
The House is under call. Senators, please record your presence. Those unexcused senators outside the chamber, please return to the chamber and record your presence. All unauthorized personnel, please leave the floor. The House is under call. Senators Decay, Jacobson, Armendariz, McKinney, Slama, Bostar, Hughes, Bostelman, Brewer, and Wayne, please return to the chamber and record your presence. The House is under call. All unexcused members are present. Members, the question is the adoption of AM 1692. All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
41 ayes, no nays on the adoption of the amendment.
The amendment is adopted. Mr. Clerk, for items, and I raise the call.
Mr. President, Senator Slama would offer, or excuse me, has MO 1032 to bracket MO 1033 to recommit, both of which are withdrawn.
So ordered.
Mr. President, Senator Slama would move to IPP the bill with a note to withdraw that as well, MO 1034.
So ordered.
In that case, Mr. President, next amendment, Senator Michaela Kavanaugh, FA 10-102.
Senator Michaela Kavanaugh, you're recognized to open on your floor amendment.
Thank you, Mr. President, colleagues. That was an unexpected debate on the last amendment. I feel like I learned a lot about courts. I do want to revisit a comment that Senator John Kavanaugh made. I think it was right after dinner before he destroyed the technology in this building with his charm and wit on the microphone. He did mention Zoom as a noun? No. Adjective? Adverb? Noun. Yeah. So, gosh, I'm tired. I can't even think. Like just all teleconferencing is now you like, oh, let's do a Zoom. And you might actually do a Google Meet, but you say, let's do a Zoom, or you might do a Skype, but you say, let's do a Zoom. And other things like that. Kleenex, Xerox, escalator. No, escalator is not. It is. Escalator is a brand name. Wow. Senator DeBoer with the deep cut. Didn't know that. My goodness. We don't say Otis when we talk about elevators. Yeah, or O'Keefe. Gonna take the O'Keefe up to the 4th floor. No, we don't do that. I actually don't know what brand of elevators we have in this building. Is it Otis? Is it O'Keefe? Is there a whole nother brand I don't even know about outside of Otis and O'Keefe? Historic. It is a historic elevator. Terrifyingly so. It is a terrifyingly historic elevator, 4 of them. And you have to be careful as to which one you get on. Yesterday, I think it was the lunch break, I was waiting for a elevator to come back down here, and it was full of 4th graders that were coming from the 14th floor, because the elevator that's right outside of my office is one of the ones that goes to the 14th floor. And I oftentimes make the mistake of not walking to the other side of my floor, the 11th floor, to a different elevator at lunchtime, which I should learn my lesson, because there's usually an elevator full of kids. But there was space for one more, so they did let me get on with them. And I like riding the elevator with the 4th graders because it's just so fun to hear their conversations. And, you ask them about the building and like, oh, what do you enjoy about the building? And they have the most random, bizarre things that I would never think of to be like their favorite thing, or things I didn't even know about. They'll talk about some piece of artwork that I've never seen. I'm like, cool. All right. I'll have to check that out. So yes, all that is to say, Xerox, Kleenex, and escalator. They are the original Zoom. This amendment strikes section 1, and that's really it. Just strikes section 1. So the underlying bill, 813, is our claims bill, right? No, it's not our claims bill. Deficit, thank you. Deficit bill. And so there you have it. It's the deficit bill. Let's look and see what the deficit bill does. See, I started my trusty binder that my staff put together for me last week. Oh, this reminds me. I was super envious, jealous, both at early on in session after bill introduction. I don't know if it was the fiscal office that put these together, the red binders that all the committee members had. Wanda? Wanda, you are a marvel. I don't know who Wanda is. She's in fiscal? Wanda in fiscal, I was blown away. I tried to steal your binder. I saw the binders being distributed on the floor and I was like, what, a binder? Like my ears perked up. There's a binder. There's a new binder. It's red. It's got lots of tabs. It's very excited. I didn't get one. So Wanda, just know, even from afar, Wanda, your work was admired and appreciated because I love a good binder. I love a good binder. At the end of Senator Sue Crawford's session, her last year, the last day, she gifted me a binder and I never felt so seen in my life. I was like, Senator Crawford, she gets me. She gets me. She gave me a binder and it had tabs. It was pretty. It was a top 10 moment. For sure, a top 10 moment. Anyways, LV 813. What do we got here? Yep, and I already read that part. So if you look at LV 813, now I am looking at the actual original LV, and then there's the AM. I haven't updated it with the ENR amendments, but I don't think that maybe they were substantial. I don't know. But the amendment that we added on general is 20 pages. And, it doesn't change, as for being 20 pages, it doesn't change as much as you would think. It's not as much reading as you might think. But I am striking definition of appropriation, period, by striking section 1, which again is essentially striking the serial Oxford comma. It is helpful. It provides clarification, but it is not actually necessary because it's the biennium, and we know that it's the biennium, and we know the period for which this appropriation is happening. It can't be for any other time period unless that time period were explicitly stated. It cannot be for a time period outside of this biennium. So it's not actually necessary. So if you were going to go on a lark and vote for any of my amendments, this is the one. Striking the Oxford serial comma of amendments. Section 1. I still wouldn't do it because it would cause people to panic, but it is an option available to you. So, and it's just defying what like an FY is. And we already know that our fiscal years start our July 1 through June 30. So again, do we need to have this? No, not really. We don't. Is it helpful? Yes. Yes, it is. Does it provide clarity? Yes. Could you discern it without it? Also, yes. But here we are. So, for the purposes of this act, any other legislative bill passed by the 108th legislature, first or second session, which appropriates funds FY 21-22, means the period of July 1, 2021 through June 30, 2022. FY 22-23 means July 1, 2023 to June 30, 2024. And it goes on from there all the way through June 30th, 2027. So it would be striking that. And from a grammatical perspective, of a greater understanding, or even a legal perspective. So much of what we put into these is, to put intent.
1 minute.
And there's lots of language in our bills that is intent, for the record, the intention, the intentionality of it all. And this is defining what we already know and accept to be true. Our fiscal year runs from July 1 to June 30. So do we need to define it on page 1 of this bill? I don't think that we do, actually. I think that we could very much consider striking that. I don't think that chaos would ensue. A lot of things that you could vote for, chaos might ensue. This, I do not believe, is one of them. So, colleagues, I encourage you to vote your heart. Vote with the serial comma or against the serial comma.
That's your
FA,
time,
thank
Senator.
you.
Senator John Kavanaugh, you're recognized to speak.
Thank you, Mr. President. Well, I'm going to vote against FA 102. I think that it's probably better, just for clarity's sake, that we leave all the list of fiscal years, what each one of them is in there. But I wanted to rise and kind of just talk a little bit more about what I was talking about in the last amendment, because I didn't get to talk again after Senator Dungan spoke last time. And I did want to take issue with something he said. He might have stepped out for a minute. He might have gone to get a drink or something like that. But he was talking about what I was talking about, but he also said one thing, and why I wanted to talk about it, was it's a distinction that might seem small to people, but I think it's a significant one. He said that people need to have the opportunity to object if they want to have their hearing in person. And I think it's important to say that the person needs to, the holder of the right is the individual, so the defendant, and they shouldn't be in the position where they have to object, or they have the opportunity to object, but more that they should be the one who gets to choose to waive. And that's an important distinction, because if you object, it means a decision's been made and you say, I don't like that decision, and then the judge can rule on that. So the judge can rule, like our chair can rule and overrule your objection and say, no, the equities and the reasons, the Roberts rules, or, well, Mason's manual, but in the courts or whatever, the law allows me to make this decision even in the face of your objection. And so putting them in that position. And then there's some, I think, disincentivization in terms of court procedure for a defendant to raise those sorts of objections about timing and procedure. But if they are the holder of this privilege, and it has to be that they have to waive it themselves, then they are less likely to be placed in that position where it's going to be forced on them. Because if they have to object, then it gets raised by somebody else, and they have to object. So it shifts it. But if they are the one that has to waive it, then it is always with them. And so they would have to be asked if they would be interested in waiving, or be presented with a scenario where it's worth their while to waive, or something along those lines. And so I think there's a distinction between waiving and objecting. And again, in an objection situation, the judge can overrule that objection. But if it's totally with the defendant, then they can't be forced to waive it. So if they refuse to waive, then it can't. The decision rests with them. The judge cannot schedule the hearing not in person. So that's a distinction I thought was an important one to make, and that's one of the things I've been talking about. And that's kind of where the rules are going of concern. That's what I'm concerned about for more particularly our rural senators, our rural judicial districts, where in the interest of, perhaps great interest of efficiency and access to the courts, the court procedures are looking for ways to increase those efficiencies. But what I'm saying is we need to be wary of the fact that if we vest too much power, give the courts too much opportunity to unilaterally, or as I read that one rule, on their own, what was the reading? District court in his or her courtroom, with the sole discretion, was the word, so that we leave it to the sole discretion of the judge, then, it can cause these unintended situations where the judge may, force somebody to have a hearing on Zoom that they would not otherwise want to have. And then that may lead to a situation where the judge makes a different decision than they would have if everybody was in the courtroom in front of them.
1 minute.
Thank you, Mr. President. So that's what I'm saying. It's an important distinction to say we need to make sure that we create a climate, an environment in which people have the opportunity to gain access to the courts through advanced technology, that courts have the efficiency, that we have these opportunities for courts to be digital, and that we can find the places where we can, yes, maybe make certain things digital and not have that be, the sole discretion or be at the discretion of the defendant. But we need to make sure that we are jealously guarding the ones where we need to make sure that it has to be at the request or the waiver of a defendant to ensure that justices continue to be served and that people get their fair shot at being heard and that everybody gets treated fairly and they do not become dehumanized through the interest of efficiencies in our courts.
That's true.
Thank you, Mr. President.
Thank you, Senator Kavanaugh. Senator Day, you're recognized to speak.
Thank you, Mr. President. I rise in support of LB 813. It's sad the 3 years that I've been here, I've gotten to the point where I now have to squint to be able to read the board from where I'm at now. This place is not good for your health, including your eyesight. Oh, thank you. Now that I have my opera glasses. Oh, I rise in support of LB 813. Not sure where I stand on FA 102. I consider myself a bit of a grammar nerd, although the many years that I have engulfed myself in the internet, I have probably lost some of my skill. But I am a firm believer in the Oxford comma, now known as the serial comma. That is something that I was not aware that it was called. But firm believer that when you are separating items in a sentence, they are distinct in their characteristics and should all be separated by a comma, because the last two things are not together. They are separate and distinct, and that would require an Oxford or serial comma. So I don't believe that I will vote for FA 102 if it is striking the serial comma. But more importantly, I know we are talking about the budget on this bill, but I think we're all aware that the underlying purpose of this ongoing filibuster is because of LB 574, and I am going to read an article that just came out, I believe maybe a couple of hours ago, in the Omaha World Herald, titled Union Pacific and 300 plus other corporations sign letter opposing anti-LGBTQ legislation. A week after more than 100 Nebraska businesses and nonprofit groups signed a letter opposing restrictions on gender-affirming care, a similar message from national corporations was sent to the state's lawmakers. The Human Rights Campaign sent a letter to state senators and Governor Jim Pillen listing businesses opposed to anti-LGBTQ state legislation. First drafted in 2020, the letter has so far amassed 319 signatures, including major corporations such as Apple, General Motors, IBM, Johnson & Johnson, Microsoft, and United Airlines. And in that sentence, they did not use an Oxford comma, unfortunately. So Microsoft and United Airlines are combined into one concept, which, as I understand it, as I asked a reporter about this, they said that when they take out the Oxford comma, it removes one character, which makes it easier to fit things into print. So that was anyways, I digress. The letter includes some companies that have deep roots in Nebraska, such as Union Pacific, which is headquartered in Omaha, or significant operations in the state, such as Amazon, Cargill, Kellogg, Google, and US Bank. Union Pacific signed on to the Human Rights Campaign business statement on anti-LGBTQ state legislation in 2021 and has a long-standing public record of supporting our LGBTQ employees and community, including membership in Nebraska Competes and our 100% rating from the HRC Foundation's Corporate Equality Index, the company said in a statement. This session, the Nebraska Legislature has been embroiled in a debate centered on Legislative Bill 574, which currently aims to ban puberty blockers, hormone therapy, and gender-affirming surgeries for individuals under 19.
1 minute.
Thank you, Mr. President. Backlash to the bill includes an ongoing filibuster by opponents that has slowed progress on all bills that have made it to the floor. The letter contends that such bills are harmful to companies' bottom lines, making it difficult for businesses in places with those restrictions to recruit qualified workers. It says such legislation deters businesses from investing in those areas. Legislation promoting discrimination directly affects our businesses, whether or not it occurs in the workplace, the letter reads. As we make complex decisions about where to invest and grow, these issues can influence our decisions. LB 574's introducer, Senator Kathleen Kauth of Omaha, called that argument fear-mongering. In fact, she suggested Nebraska economic prospects might be harmed if it fails to pass such legislation, since many of the state's residents are conservative.
That's your time, Senator.
Thank you.
Thank you. And Senator Conrad, you're recognized to speak.
Thank you, Mr. President. Good evening, colleagues. I wanted to touch upon, in my earlier remarks, I said I wanted to really focus my remarks on LB 813 in regards to 3 areas that are contemplated in the measure: higher ed, corrections, and housing. I've had, I think, ample opportunity to talk about some of my concerns in regards to the higher ed resources in the overall budget package, and hope to continue the conversation over the course of the next few years to make sure that we are meeting the needs of a modern system of higher education and honoring our commitment to ensure an accessible, high quality higher education opportunity for all Nebraskans. Next, I'd like to touch upon the corrections aspect of this measure. And if you look on page 74 and 75 of your budget book, you can see a little bit more about the significant costs in this measure that really emanate from 2 primary areas in the Department of Corrections. The first is an increase in the annual, and this is statutory language, not mine, inmate per diem costs, and that ensures that we're providing enough resources to meet inflationary pressures hitting the Department of Corrections when it comes to the provision of food, health services, electronic monitoring, and other expenses. So that's a $12.8 million price tag on that regard. And then if you look at the very next line, you can see that there's a $12.1 million cost in terms of salaries that we need to take care of in regards to the Department of Corrections. That includes the negotiated salary increases, which of course are long overdue for frontline first responders in our Department of Corrections, but of course, public employees writ large. I know we haven't had a chance to talk a great deal about it thus far, but I actually think that that negotiation and that commitment to provide increased compensation and benefits to state employees is one of the brightest spots in the budget, and I'm glad to see that finally be addressed. But I wanted to highlight these significant price tags in regards to the interplay with the Department of Correctional Services in this measure. We had a pretty significant, and I thought overall pretty thoughtful debate on general file about the costs of corrections and about the costs of the massive new prison, which would be one of the most expensive and complex earmarks in state history, and will do very little, if any, to actually address our prison overcrowding crisis. And of course, does not count for ongoing maintenance and operations, and that includes significant costs for employees, for staffing, for ensuring the kind of programming that we need to see to address recidivism and ensure that when people return to our communities, they're not coming home more sick or more hopeless and more likely to reoffend, but rather better able to deal with life's challenges and better able to commit to pro-social activities and ensure a successful reentry. That advances our shared public safety goals, which I just wanted to lift up. But we had a chance to talk just a little bit about how we kind of got in this mess in terms of mass incarceration, what that means from a fiscal perspective, and then some of the solutions that we need to look at, not only within the budget, but of course,
1 minute.
pending before the, thank you, Mr. President, pending before the Judiciary Committee and other jurisdictional committees that touch upon smart justice reform. So I'm going to hit my light again because I'm not sure if I'm going to have enough time to touch upon some of the root causes driving mass incarceration and racial injustice in Nebraska, some of the solutions attendant to those public policy challenges, and then tie it into the fiscal matters contemplated in our budget and in this deficit appropriation bill. Thank you, Mr. President.
Thank you, Senator Conrad. Senator Vargas, you're recognized to speak.
Thank you very much, President. A couple of things I wanted to talk about. So for the Affordable Housing Trust Fund, there's been several of us that have been working on housing for the last several years. It started with Senator Williams in the past with the Rural Workforce Housing Fund and has continued on with Senator Breezy and myself and Senator Ibach and Senator McKinney in terms of the work we're doing. But a lot of the work we've done with the Affordable Housing Trust Fund, and part of the reason I want to speak to it is because at some point, we're going to need to continue to look at how we can make sure these dollars are getting out to more affordable housing, this grant program, more affordable housing projects across the state. So as in page 75, and it's referencing this, Affordable Housing Trust Fund was created in 1996, resembling its current form. In 1997, it receives about 95 cents for each $1,000 value or a fraction thereof. The important part about this is why we increased. Somebody thought we were appropriating $10 million more dollars to the fund, when in reality, what we were doing is increasing the authority of cash funds. And part of this was due to the higher than anticipated increase in real estate activity. The fund balance has exceeded the forecasts. And sometimes what we see, and we had this conversation a little bit with the Universal Service Fund, and we have more revenue and funds going into different cash funds, in this instance, the Affordable Housing Trust Fund. You want to make sure that those dollars are being used, getting out. We're not letting them build up a balance so that become overwhelming. The conversation we had on the floor about the Universal Service Fund, and we've had about some of the Game and Parks cash funds, has been these funds continue growing and they keep growing. And then sometimes we do utilize them. Sometimes we sort of underspend. And it's incumbent on us to make sure we're investing these dollars appropriately. And for the Affordable Housing Trust Fund, there is more revenue so we can be able to utilize it more effectively. Again, this program is run through DED. It's got a competitive grant process. We've actually, in the last several years, made this grant process much more competitive and have also reduce some barriers to make it easier for different groups, different organizations to be able to apply, while still holding a high bar for the Department of Economic Development as they're reviewing applications. There are projects across the entire state. This is both urban and rural. I encourage people to go and contact DED, go on a site visit to some of these wonderful projects that are created from this Affordable Housing Trust Fund. It is the only truly ongoing affordable housing program that we currently have in the state of Nebraska. This is one of the opportunities we have for home ownership for working families. And if we didn't have the dock stand tax, at least the statute that funds this, we wouldn't have the investments in affordable housing that we have. And what we've seen these last several years is there's an ongoing need to invest in homeownership. I've mentioned this several times in committees. I don't think I've mentioned it on the mic. the reason why I work on affordable housing and that many of us have worked on this is because I feel like it's the most universal thing that we can agree to. It is completely bipartisan or really truly nonpartisan that it doesn't matter if you were born in Gary, Nebraska or Omaha or anywhere in between, that everybody is seeking their first home. Everybody is seeking that home ownership, that first piece of the American dream, and they want to make sure it's affordable. And I'm really thankful we have effective, useful Department of Economic Development programs that are trying to make that reality possible for people. So my hope is that there's a senator that takes up the charge with the Affordable Housing Trust Fund, making sure that we're investing in it, making sure the dollars are getting out, the balances aren't being built up, they're going to effective projects, works hand in hand with DED, like many of us have these several years, and is also looking to making sure these other programs are even more effective. These workforce housing programs are real opportunities that are investing in home ownership across the state in both rural and urban Nebraska, and wonderful projects. And that is not something that is funded ongoing. Those are when we fund it, it gets an infusion of funds, and that's in a separate bill. But for the purposes of this, for the Affordable Housing Trust Fund, I'm just encouraged that it has been so effective. We're getting the revenues in, and we want to make sure these dollars are going out, because about 7 years ago, there was a report that said these funds were building up and it wasn't working as effectively as it could. And we are trying to rectify that. Thank you.
Thank you, Senator Vargas. Senator Urban, you're recognized to speak and wave. Senator Day, you're recognized to speak.
Thank you, Mr. President. I'm going to continue reading this letter that came out in the Omaha World Herald today titled Union Pacific 300 plus other corporations sign letter opposing anti-LGBTQ legislation. Excuse me. I spilled on myself. Mike Hornacek, CEO of the nonprofit Together Omaha and LB 574 opponent, said he knows that not all conservatives support the bill. And this also reflects many of the comments that I have heard in my own life, anecdotally from conservatives and Republicans that I know. The Human Rights Campaign letter reflects similar statements made in the letter that Hornacek drafted and sent to lawmakers last week. The more than 100 signatories to this letter said they opposed LB 574 and a similar Couth bill, LB 575, which would regulate transgender students' access to bathrooms and locker rooms and their participation in school sports. Some of the businesses and groups who signed the Hornacek letter said they have harassed, no, there's a word missing. Some of the businesses and groups who signed the Hornacek letter said they have been harassed by supporters of the bills. But Hornacek said he hasn't been asked by any businesses to retract their signatures. I'm not sure if somebody mentioned this on the mic yesterday, but there were multiple reports of the businesses that signed on to the initial letter locally, I think, from the Omaha area of, 115 businesses opposing LB 574 who received harassing phone calls with various just really nasty things that were said, voicemails left on their phones, basically trying to bully them into asking to retract their signatures from the letter that was sent in opposition to 574. Hornacek said it's difficult to know the level of legitimate danger behind such harassment. As a parent to a transgender teenager, he said that he constantly fears for his family's safety since he started speaking out. He said it's disappointing that Nebraska has reached a point where there can't be real dialogue about these issues. If we listen to experts in this area, we wouldn't even be here, Hornacek said. And then the letter itself from the Human Rights Campaign, business statement on anti-LGBTQ state legislation. For years, business leaders have shared the detrimental business impacts of policies and debates that exclude LGBTQ people from full participation in daily life, including negative impacts on workforce, recruitment, productivity, and bottom line. In recent years, these policies have increasingly targeted LGBTQ youth, including a variety of attempts to isolate transgender youth and to make schools less safe and inclusive for LGBTQ young people. Today, we are seeing further expansion into policies that would block mention of LGBTQ inclusive families in schools, lead to book banning, and even attack the sexual harassment prevention, safe workplace, and diversity, equity, and inclusion trainings and programs that are essential to corporate operations, ethics, and legal obligations. These issues remain major concerns for business leaders who are hearing concerns from employees and recruits about safety and inclusion for themselves and their children in states where such policies are pursued. The cumulative effect of these many attempts to exclude LGBTQ people is real, and these business signatories remain impacted by these issues. This letter, originally published in 2020 as a joint letter with Freedom for All Americans.
1 minute.
Thank you, Mr. President. Continues to grow as business leaders seek to ensure that their team members feel safe and included everywhere they operate. So far, 319 companies have signed the business statement opposing anti-LGBTQ state legislation, stating their clear opposition to harmful legislation aimed at restricting the access of LGBTQ people in society. We are deeply concerned by the bills being introduced in state houses across the country that single out LGBTQ individuals, many specifically targeting transgender youth, for exclusion or differential treatment.
That's your time, Senator.
Thank you, Mr. President.
Thank you, Senator Day. Senator Conrad, you're recognized to speak.
Thank you, Mr. President. Good evening, colleagues. I wanted to continue to help connect the dots about the budgetary implications in regards to the impact on the taxpayer and the detrimental effect on moving so many of our precious state resources into the Department of Corrections through not only the deficit appropriations bill, but of course the mainline budget, capital constructions and transfers as well in relation to maintaining spending, picking up increases in salaries and other needed items. And then of course the explosion in terms of costs when it comes to the massive new prison that will do little, if any, to address our prison overcrowding crisis, which has been declared under state law and will continue until our operations get, until we get below 125% capacity, and that's nowhere in the near future. So I do think the massive new prison is a mistake, particularly without a plan for smart justice reform, because not only is this prison unaffordable and without merit unless we can address those long-term challenges. The recent reports from the experts that we have asked to look at this have indicated unequivocally that it's not really one new massive new prison, it's actually two. And we do not have a budgetary projection in place to fund that kind of significant impact in our budget. So we see in the deficit appropriations, we see ballooning, skyrocketing costs on overtime. We've had a prison staffing emergency in place for some time. I believe now it is specifically focused on just a few institutions instead of system-wide, but we're currently under state law, under a prison overcrowding emergency and a staffing emergency at at least a few of our facilities, and that's deeply concerning. And we're committing millions and millions, hundreds of millions of dollars to a crisis-riddled Department of Corrections with no plan for how to stem the tide, in contravention to the approach taken by our sister states that have engaged in smart justice reform and the federal government through the enactment of a variety of measures, including the First Step Act. So we have a little time together. How did we get here? We got here really because of decades of inaction, a lack of political will to commit to smart justice reform, despite consensus ever growing across the political spectrum in our sister states and on the federal level. We've seen a lack of meaningful discretion for our hardworking independent judges to provide meaningful alternatives to incarceration and to ensure that the sentence is derived and meted out on a case-by-case basis outside of extreme sentencing measures like the habitual criminal law or the mandatory minimum law, particularly for nonviolent offenders, which still comes into play. We've seen a broken parole and probation system that was highlighted just very recently by an expose in the Flatwater Free Press, thanks to the leadership of Senator McKinney in bringing forward accountability legislation to just get the parole board members to show up to do their job, and what an impact that had on individual lives and helping to address these issues. Thank you, Mr. President. In terms of mass incarceration, we've seen a lack of transparency and accountability for county prosecutors across the state in contravention to growing and emerging trends that we've seen in other states. And we see this continual doubling down, creation of new crimes, and exacerbation of existing crimes and penalties in the state house to prison pipeline. So that's how we got to where we are. And what does that mean? So not only do we have the most overcrowded prison system in the country, but think about that in human terms as well. About 1 in 10 kids in Nebraska are going to have a parent in the criminal justice system. Let that sink in. What does that mean for our educational goals? What does that mean for our shared prosperity? Think about how unwieldy this system has grown. We have significant racial disparities at every stage of our criminal justice system. More than half of those incarcerated are there for a nonviolent offense.
That's your time,
Thank you, Mr. President.
Thank you, Senator Conrad. Senator Michaela Cavanaugh, you're recognized to speak.
Thank you, Mr. President. I have been having off the mic conversations about controversial topic as to whether or not the movie Die Hard is a Christmas movie or not. And I really need to process my feelings about some of the responses I've received on this. So I will be digging in on that topic at a later time and date. And for now, I would just yield the remainder of my time to Senator John Kavanaugh.
Senator John Kavanaugh, that's 4 minutes and 35 seconds.
Thank you, Mr. President. Well, thank you, Senator Michaela Cavanaugh. I think Die Hard is a Christmas movie, and I could talk about that for a while as well. But I did want to talk a little bit more about courts and access to courts and things. But I did want to point out, it's starting to get warm in here again. It got very warm in here last night, and I was hoping we could have further air conditioning this evening. And so I know Senator Erdman pointed out last week that we need new light bulbs, and that seemed to spur people into action to get new light bulbs. So I'll just say to, building commission that maybe we could have the air conditioning on in the legislative chamber in the evenings when we're here late, because we are one of the 3 branches of the government and very important work we're doing. And maybe we might do it a little bit more thoughtfully if we're not all really hot and not, it's just harder to think straight when you're just overheated and getting dehydrated from sweating so much. But anyway, so I digress, but I just take this opportunity for the record. So I started talking right after dinner about the importance of technology in our courts, but also the importance of not overly being dependent on it. And I thought it was particularly apropos that when I was in the middle of speaking on my second time, actually it was Senator Michaela Cavanaugh's time, but it was the second time I was speaking, the entire building shut down. So the boards up here shut down, the cameras filming us shut down, the lights all turned off, our microphones turned off, the recording turned off, everybody everywhere else in the building all turned off, and they came back on pretty quickly. But then it took a while for the board to get back to right, to get the microphones turned back on and the recordings. And those of you who are now watching on these cameras didn't get to see, I stood here the whole time because I didn't know when we were going to come back up, and I was in the middle of talking. And we did get the microphones back at some point, but I couldn't continue talking because we didn't have the recording. And so then we got the recording back. And so I started speaking again. But then for the next, I don't know how long it was, 15 minutes or so, the camera broadcast wasn't back up yet either. And, technology, these things, they take a while to get back readjusted. And it's of no fault of anybody in this building, because clearly the whole building went down. So it was probably some external factor, force majeure, act of God, however you say it. But this is relevant. It was, I think, very interesting that we're talking about over-reliance on technology. The folks at home, you didn't get to see what was happening here. Wasn't that interesting. But I mean, I was talking, but other than that, but we couldn't conduct the business because we weren't recording. And so we have become dependent on the recording to the point where who knows how long, if that shut down, what we would have done. Lose the remainder of the legislative day. We've been working for 2 hours since then, and we'll work for a few more. But my point is, in the context of this broader conversation, this technology is great. It allows the folks at home to watch this. It allows us, now we're going to be recording these thanks to Senator Brewer. It allows us all to see these boards and know what's going on. It allows us to go on our computers and see what the bills are in particular, and the amendment is, what this FA 102 is that I oppose is about. And these recordings allow people, thank you, Mr. President, to go and, get these things, listen to the recordings and all these things. And the transcribers then can record it at a different time. All of those things are great. But when they don't work, we can't do what we're supposed to do. We can't get our business done. And so I started all this talking about access to the courts is improved by this technological improvements, and that we are having more opportunity for people to get in court in all these different ways. But we don't want to become overly dependent on it to the point where we cannot conduct the essential business of our state and of our courts, because we become so reliant on a technology, though great, is fickle and can be subject to a lightning strike or a severed telephone line or a power outage. And then we can't do the work that we could do if we were all sitting in this room together, just if the only thing we had to do was talk to each other in person. So that's, I thought, was a pretty interesting distinction or point.
That's your time.
Thank you, Mr. President.
Thank you, Senator Kavanaugh. Senator Day, you're recognized to speak, and this is your last time on the motion or floor amendment.
Thank you, Mr. President. I am just going to finish reading this business statement here, and then I am done talking for the night because I am tired. It's 8:19. If I was at home, I would definitely be in my jammies, ideally in bed, watching the latest episode of Succession that I have not been able to watch yet. And I am dying to get the opportunity. It likely won't happen tonight because I will go directly to bed when I get home because I'm a very sleepy person. So again, the letter that was sent out, 300 plus businesses, including Union Pacific, sign a letter opposing anti-LGBTQ legislation. I will remind everyone we're talking about Union Pacific, which we know is headquartered in Omaha, and then some other large corporations that have significant operations in the state, like Amazon, Cargill, Kellogg, Google, and US Bank all signed on to this letter. The full statement reads, the companies joining this statement do business, create jobs, and serve customers throughout the United States. Our businesses strongly embrace diversity and inclusion because we want everyone who works for us or does business with us to feel included and welcomed as their true, authentic selves. Fairness, equal treatment, and opportunity are central to our corporate values because we care about our employees and the customers we serve. What's more, these values also matter to our bottom lines. Inclusive business practices lead to more productive and engaged employees, increased customer satisfaction, and ultimately improved competitiveness and financial performance. We are deeply concerned about the bills being introduced in state houses across the country that single out LGBTQ individuals, many specifically targeting transgender youth for exclusion or differential treatment, like LB 574. Laws that would affect access to medical care for transgender people, parental rights, social and family services, student sports, or access to public facilities such as restrooms, unnecessarily and uncharitably single out already marginalized groups for additional disadvantage. They seek to put the authority of state government behind discrimination and promote mistreatment of a targeted LGBTQ population. These bills would harm our team members and their families, stripping them of opportunities and making them feel unwelcome and at risk in their own communities. As such, it can be exceedingly difficult for us to recruit the most qualified candidates for jobs in states that pursue such laws, and these measures can place substantial burdens on the families of our employees who already reside in these states. Legislation promoting discrimination directly affects our businesses, whether or not it occurs in the workplace. As we make complex decisions about where to invest and grow, these issues can influence our decisions. America's business community has consistently communicated to lawmakers at every level that such laws have a negative effect on our employees, our customers, our competitiveness, and state and national economies. As business leaders dedicated to equal treatment, respect, and opportunity for all, as well as to improving the financial and investment climate across the country, we call for public leaders to abandon or oppose efforts to enact this type of discriminatory legislation and ensure fairness for all Americans.
1 minute.
I will yield the rest of my time. Thank you, Mr. President.
Thank you, Senator Day. Senator Conrad, you're recognized to speak, and this is your final time on the floor amendment.
Very good. Thank you so much, Mr. President. And I failed to give credit where credit was due. Of course, the presiding officer, who now serves as our lieutenant governor, has a long and distinguished career as a prosecutor in our community, and then also on the state and federal level as well. And I'm well aware of some of the innovations that he brought to the office in the Lancaster County Attorney's Office in regards to prosecutorial transparency. That were really cutting edge and should be more closely examined by our prosecutors across the state for a more uniform and modern application, because I think it would be instructive and helpful to an overall smart justice approach to reforms. So even though I believe that this massive new prison is untenable from a moral and fiscal perspective, I do believe we are taxing ourselves to death to fuel mass incarceration and racial injustice. If this body is committed to providing those resources, as it seems that it is, it does not alleviate our obligation to also pursue as robustly a course for smart justice reform. That must happen. That must happen this session. Those conversations must continue to come forward in the over the biennium and into the next year. And what does that look like? Friends, it's not academic. We don't have to guess. There's been study after study after study to show us what smart justice reform looks like. I know Senator Wayne has been working tirelessly to try and bring forward a smart justice package to help address these issues and the inherent human rights abuse and racial injustice components of these policy dilemmas as well. But we have to admit to ourselves and each other and the public that we cannot afford to build our way out of this crisis. We have to ensure that we take a multifaceted approach to addressing this multifaceted problem. But we can learn from the examples of our sister states for how to do it. We got to take up the front end. That means sentence reform. That means diversion. That means problem-solving courts. That means mental health care and treatment services. We got to make the inside investments. That means an infusion of money to make sure that our hardworking correctional staff is safe and has the resources that they need to help people turn their lives around. We got to ensure that we have the programs and services in place to address recidivism. And we know from our own reports that there is a backlog. People are waiting to access programs and services that will advance our shared public safety goals. And we got to address the back end. That means smart innovations in parole, in probation. That means improved access access to pro-social activities like voting, like civic engagement, like removing barriers to accessing the safety net, whether that's food assistance or Medicaid assistance. And we have to remove barriers to education and employment. I have introduced an interim study on these very topics to at least address some of our re-entry opportunities to make a difference in breaking cycles of recidivism. The good news is there's bipartisan support for these smart justice measures in our sister states and on the federal level. The good news is we can learn from these examples. The bad news is it's going to take a shift in our politics, in our political will. We're going to have to shed some of the tired thinking about being tough on crime and waging a war on drugs. We have to start to choose a better path, because the impact for humans, the human impact, the family impact, the fiscal impact, thank you, Mr. President, is untenable and unsustainable and unaffordable. So we have to be unafraid to address these crises. We have to learn from the examples that are out there, and we have to figure out a better way to save money, have better outcomes, and to ensure that our shared public safety goals are advanced. The status quo does not keep us safer. Building a massive new prison is bricks and mortar. It's a fancier box. It doesn't keep us safer. We have to be able to ensure when we're committing these resources, we're keeping our communities safer. We do that through smart justice reforms. Thank you, Mr. President.
Thank you, Senator Conrad. Senator Kavanaugh, Michaela Kavanaugh, you're recognized to speak, and this is your last time before you close.
Thank you, Mr. President. I still am processing the Die Hard conversation. Is it a Christmas movie? Is it not a Christmas movie? Have you seen it? If you haven't, prioritize that. My oldest child has seen Die Hard when they were 24 hours old. Watched it with me in the hospital. Took a picture. It was on Facebook, and I love every time it comes up to remind me that we watched Die Hard together right out of the gate. Senator John Kavanaugh, I agree. It absolutely is a Christmas movie. It is set at a Christmas party. Clearly, it's a Christmas movie. Senator John Kavanaugh had given somebody else examples, further examples beyond just the party, how he taped the gun to his back using wrapping paper. It's a Christmas movie. It's undisputable fact that it is a Christmas movie. I mean, maybe it's disputable, but I don't think so. I take it as a fact that Die Hard is a Christmas movie. Now, I'm not talking about the other Die Hards, the original, the real deal Christmas movie. I feel like I may have opened up a major controversy with this conversation, so I am going to withdraw my amendment. Thank you, Mr. President. You're good.
Mr. Clerk.
I have nothing further on the bill, Senator.
Senator Frederickson for a motion.
Thank you, Mr. President. I have the distinct honor to move to advance LB 813 to ENR for engrossing.
Senators, you've heard the motion. All those in favor, say aye. All those in favor, vote aye. All those opposed, vote nay. Record, Mr. Clerk.
25 ayes, no nays on advancement of the bill to ENR for engrossing.
LB 813 is advanced to ENR engrossing. Mr. Clerk for items.
Mr. President, next bill, LB 562. First of all, Senator, there are no ENR amendments. I have a motion from Senator Hunt to bracket LB 562 until June 2nd, 2023, MO 646.
Senator Kavanaugh, you're recognized to open on the motion.
Thank you, Mr. President. Okay, LB 562 has been a fun ride. Get it? Car, driving, ethanol. It's 8:33. It's been a long couple of days. My punny jokes are not punny at all. I'm not going to reopen the controversial conversation regarding Die Hard. So on general file, LB 562 went to cloture without a vote on the committee amendment, and that has caused a significant amount of heartburn for, well, people in the chamber, people outside of the chamber, but also staff. And I do not want to continue to cause heartburn for staff. So I'm going to make sure that we get to that today or tomorrow or whenever. Essentially, the amendment's coming. In addition to that, I appreciate and value Senator Dorn, and we've worked together for several years, and we've sat next to each other, we've sat in front and behind one another, and I know that this amendment that is pending makes the bill better for pretty much everyone involved. So with that, I will slowly say that I will withdraw the motion. Thank you, Mr. President.
So ordered. Mr. Clerk.
Senator Kavanaugh, I have MO 645 from Senator Hunt as well as MO 644 from Senator Hunt, both with notes to withdraw.
So ordered.
In that case, Mr. President, Senator Raybould would move to amend with AM 1378.
Senator Raybould, you're recognized to open on the amendment.
Thank you, Mr. President. This amendment is actually for the amendment, but Mr. President, I believe this amendment is for the amendment that is yet to be introduced. Could we get a clarification, please?
Mr. Clerk.
Apologies, Senator. The committee amendments were not adopted on general file. Therefore, the first amendment up on select will be AM 1248.
Senator Holloran, you're recognized to open on the committee amendment.
Well, thank you, Mr. President. Good evening, colleagues. This has been a bumpy ride to get to the committee amendment. A few detours along the way, but here we are. We spent 8 hours in general on LB 562, and this is a white copy amendment I'm about to read to you. It is the bill. And so all the debate we had on general was pretty much for naught because this changes the bill. The Agriculture Committee Amendment, AM 1248, is a white copy amendment that becomes the bill. The committee statement provides a fairly detailed section by section description of LB 562 as introduced and as amended that I would encourage you to consult as we proceed with the debate today. But I will quickly walk through the most significant changes in the amendment and the committee's intent behind them. I want to stress that our committee worked diligently to bring you a compromise amendment today for your consideration. Countless hours, countless options, amendments, and concepts were debated prior to gaining support for AM 1248. First, the committee amendment rewrites the standard in a more readable and understandable way. As clarified by the amendment, there are actually two parts to the E15 standard. First, the E15 access standard trigger mechanism replaces what was perceived as a mandate in the original bill. A trigger mechanism better reflects the shared goal of gas stations in the ethanol industry to give consumers the freedom to choose homegrown ethanol blends that will give Nebraskans a range of fuel options and bigger savings under a structure that incentivizes this activity rather than mandate it. The trigger mechanism is set at a blend rate percentage in the future, which reflects the shared goal and will be tracked using existing reporting capabilities within the Department of Revenue. New construction standards remain in the bill. However, requirements for replacement and upgrades have been removed while retaining a narrow provision, as requested by the gas station industry, that would only apply to replacement and upgrades that impact more than 80% of a facility. There was a great concern by the gas station industry on requirements that would occur when infrastructure is replaced or upgraded. Adopting an 80% standard makes it clear that major overhauls and only new construction are impacted by this particular provision. The amendment retains the provision that neither standard applies during any time the fuel infrastructure at the site is under construction. The amendment retains the authority for the governor to waive the standard during periods of E15 shortage or pricing volatility causing consumer harm. The amendment also retains another exemption for sites where all fuel tanks are constructed of certain materials and manufactured prior to specified dates. As a result of negotiations, through several exemptions and waivers have been enhanced to address concerns. The amendment retains a waiver for when costs to comply are substantial, but dramatically reduces the threshold at which that cost waiver kicks in. Gas stations express concern over the amount, and so the cost waiver will now offer a waiver to the standard to offer E15 from at least one dispenser if the cost of compliance would exceed $15,000 rather than $100,000 in the original bill. This reduction encourages and incents the transition to E15 without burdening gas stations who are not equipped to sell E15. The amendment also retains a small volume exemption. In the original bill, this was a waiver that was required to be applied for at each location. Out of a desire to make the program as accessible as possible and limit regulatory complexity under the amendment, is now an exemption that the retail location simply attests to. And the amendment allows a retailer to claim the exemption for multiple sites. Lastly, the committee amendment opts to enhance the refundable income tax credit the retailers who sell E15 and higher blends of ethanol may claim rather than providing cost share assistance. After conversations, enhancing the tax credit was preferred mechanism among all parties to further incent the transition to E15 and make this transition as economically viable for participating gas stations. LB 526 was heard by the committee on February 7th. It was a well-attended hearing with a number of testifiers both for and against the original bill. There's been a lot of work by Senator Dorn, committee members, and others behind the scenes since the hearing to try to find a means to enable consumers to have a greater access to E15 fuels at least disruption and inconvenience to the industry. These proposed changes satisfy a number of concerns of opponents, and many no longer oppose the bill. I move the adoption of AM 1248 and the advancement of LB 562.
Thank you, Senator Halloran. Senator Hughes, you're recognized to speak.
Thank you, Mr. President. I rise to talk about, or I support AM 1248 and to LB 562. I was part of the Ag Committee and was in attendance for the hearing on this bill. The original bill of 562 was originally presented. I was not a fan. In my opinion, it was a total mandate. This bill, as it was written, would have required gas stations to put E15 at half of all their pumps by January 1st of 2024. And if it costs you over $100,000, then you got a waiver. But if it costs you $99,000 or less, then you had to do it. There were some money for granting in if you did have to do that. Last year, a bill was passed that gave a 5-cent tax credit per gallon for E15 sold. And my question at the time was, why wasn't this allowed to work before the stick was brought in? I have said multiple times, I am for a carrot and not a stick. So there were several of us on this Ag Committee that worked very hard to make this bill better. We held meetings with all parties involved to come to the table and discuss the issues. We had the retailers, the ethanol producers in a discussion. Ethanol kept repeating, we are the second highest, as a state, Nebraska is the second highest producer of ethanol, and yet we're at the bottom 10 states that sell it. Our state average of ethanol sold is 9.7%. And we need to have ethanol purchased here. So ultimately what we came about, which is what this amendment does, is we said, what is that goal? And so AM 1248 was created, which makes this bill better. It sets a goal of 14% ethanol blend to be sold. And if that is met by January 1st of 2028, then no mandatory switching is mandated. We also did more with the incentives. And for example, in 2023, we have a 5-cent per gallon credit for ethanol, every gallon of E15 sold. In 24, it goes up to 8 cents. In 2025, 9 cents. 2026, back down to 8 cents. And 2027, 7 cents. So those incentives are in place to try to help get our retailers to get to that goal of 14% ethanol sold here in Nebraska. The State Department will also do, I believe it's a monthly report of where we're at in terms of that ethanol blend sold. So our retailers will see our tracking toward that goal. We also lowered the limit of what it costs to make that change. If, for example, we're not at that 14% goal, we lowered it from 100,000 to 15,000. So if it would cost you more than $15,000 to make that switch over, then you do not have to do the change. And then there's some other options in there. If you sell less than 300,000 gallons a year of gas, you don't have to make the change, et cetera. So colleagues, we spent a lot of time on this bill and we went round and round with the main players. In fact, I was just talking with one of the lobbyists and he's like, I'm so sorry of being a pest on this. So it was a lot of work to do this, and I feel like we have made it better with this amendment. So please would ask you to vote yes on AM 1248 to LB 562. Thank you, Mr. President.
Thank you, Senator Hughes. Senator Raybold, you're recognized to speak.
Thank you, Mr. President. I do want to commend my colleagues on the Agriculture Committee. I am a very proud member of the Ag Committee, and I know that we work pretty hard on trying to come up with compromises, working with the ethanol industry, the Corn Board, and a lot of the retailers, and trying to work through all their objections. I know a lot of the discussion focused on it's a mandate. And yes, it is a mandate. We want to support agriculture in our state. And I think the compromises that we worked out are more reasonable than what they were before, and more appropriate goals that we set are more realistic and appropriate. The enforcement side is still somewhat harsh, because it gives the Department of Agriculture may suspend or revoke a retailer's weighing and measuring establishment permit. That means that's your permit to operate your fuel center if you are not in compliance. Now, I know the amendment makes it clear the process that retailers have to go through to get that waiver, They are also willing to work with that retailer to get the waiver, particularly for those smaller one fuel center independent operator, to give them the additional time. And in many cases, the older operator, meaning not the person, but the station itself, has old, outdated underground storage tanks that would not be able to be converted because ethanol blends are a highly corrosive blend of fuel. So I do stand in support of this amendment. I think it makes the whole bill a lot better. I'm a big fan of sunsets, and this does have a sunset of 5 years. We're here to help support the ethanol industry. I think it's reasonable, the 5 years, and it's up to future colleagues to either try to renew it or not. Of course, I can see the future as well when it comes to vehicles that are driving our economy, and I know that electric vehicles are becoming more and more popular. And I know Senator Halloran and I went back and forth. What do our customers want? Will they come and tell me they want E15 or E30 in our fuel stations? And the reality is they do tell us what they want. And it's funny, we have some electric vehicle charging stations at some of our fuel centers. And the minute one of them goes down, I start getting calls from customers saying, we need the EV charging station back up. And so I can see it's going to be the wave of the future. We know that every single automobile manufacturer has electric vehicles or electric models in their lineup, and some are actually going to be going to all electric vehicles. We know that within 5 years, they're going to be a predominant player in the automobile industry, and within 10 years, probably every single family in the United States will have an electric vehicle. So I do support AM 1248. The one thing that we sort of launched in talking about is my amendment. And my amendment is specifically for those retailers that request a waiver, and the Department of Agriculture can take quite some time to review the waiver. Thank you, Mr. President. And the idea is once they either approve, but when they deny, my amendment gives that retailer 90 days to be in compliance. If we don't have that 90 days to get into compliance, the fuel station runs the risk of losing their license to operate. And a 90-day compliance is standard in the business world. And so I ask my colleagues to please support AM 1248, but also support my amendment that's coming up very soon. Thank you, Mr. President.
Thank you, Senator Raybould. Seeing no one else in the queue, Senator Halloran, you're recognized to close on the amendment and waive. Members, the question is the adoption of AM 1248. All those in favor? A request for a roll call vote. Mr. Clerk.
Senator Aguilar, Senator Albright, voting yes. Senator Arch, voting yes. Senator Armendariz, voting yes. Senator Ballard, voting yes. Senator Blood, Senator Boston, voting yes. Senator Bostar, voting yes. Senator Bostelman, voting yes. Senator Brandt, voting yes. Senator Brewer, voting yes. Senator Breezy, voting yes. Senator John Kavanaugh, voting yes. Senator Michaela Kavanaugh, not voting. Senator Clements, voting yes. Senator Conrad, voting yes. Senator Day, voting yes. Senator DeBoer, voting yes. Senator DeKay, voting yes. Senator Dorn, voting yes. Senator Dover, Senator Dungan, voting yes. Senator Erdman, voting yes. Senator Frederickson, voting yes. Senator Halloran, voting yes. Senator Hansen, voting yes. Senator Hardin, voting yes. Senator Holdcroft, voting yes. Senator Hughes, voting yes. Senator Hunt, Senator Ibach, voting yes. Senator Jacobson, Voting yes, Senator Cowth. Voting yes, Senator Linehan. Voting yes, Senator Lippincott. Voting yes, Senator Lowe. Voting yes, Senator McDonald. Voting yes, Senator McKinney. Senator Mosier. Voting yes, Senator Merman. Voting yes, Senator Raybold. Voting yes, Senator Reapy. Not voting, Senator Sanders. Voting yes, Senator Slama. Voting yes, Senator Vargas. Voting yes, Senator Von Gillern. Voting yes, Senator Walls. Voting yes, Senator Wayne. Senator Wishart. Voting yes. Vote is 41 ayes, no nays, Mr. President, on adoption of the amendment.
The amendment is adopted. Mr. Clerk, for items.
Mr. President, next amendment on the bill, Senator Raybold would move to amend with AM 1378.
Senator Raybold, you're recognized to open on your amendment.
Thank you, Mr. President. I'll try to be brief and ask my colleagues to please support this. The amendment just permits the retailer, if they are denied the waiver, that their fuel station does not need to comply. If they're denied that, then they're given 90 days to get the fuel station in compliance. And that would allow them to not be subject to having their license revoked. And so I do ask my colleagues to please vote in support of that. That is a very reasonable standard business request. Normally it's in most contracts. If you're not in compliance, once you're given a denial, you're given at least 60 to 90 days to get into compliance. And that is my only comment I have. And if there's no other people in the queue, I'd like to have a roll call of the House.
Actually, Senator Halloran is in the queue. Okay. You're recognized to speak. Yes, you're recognized to speak, Senator Halloran.
Thank you, Mr. President. I'd like to address AM 1378. AM 1378 is not seen as a friendly amendment to the bill for a couple of reasons. First, the amendment seeks to address a stated concern that isn't problematic. First, the E15 requirement may never come into being if the blend rate goal is hit. Before we ever get to a place where a retailer is considering the need for a waiver, we'll have nearly 5 full years of tracking the state blend rates under the compromise version of the bill. Over those years, retailers will have regular updates on where we are in terms of that trend line, and will have the ability to make business plans based on those trends, knowing well before 2028 what they'll need to do. Furthermore, at Senator Raybold's request in the committee, Section 10 of the compromise amendment includes a 3-month delay in the timeline for when the department can take any action if the blend rate goal is not met. I would point out that this ultimately provides retailers with a full 15 months of additional time beyond what the introduced version of the bill would have gained. So I would encourage a red light for AM 1248. Thank you, Mr. President.
Thank you. Thank you, Senator Halloran. Senator Raybold, you're recognized to speak.
Thank you, Mr. President. I do appreciate Senator Halloran's concern, but since there is a cost associated with the conversion, a minimum cost that fuel station has to incur, I would respectfully say that there is compliance and data that you have to provide to the Department of Agriculture to verify the age of your equipment, the style and make and model of your tank, to see if it is going to be exempt. You have to have a third party come and verify the information that you're presenting to the Department of Agriculture is true and accurate, that your equipment is too old to convert. And I think it's only fair that some retailers are not interested in selling an ethanol blend other than what they already have. The most popular ethanol blend is E10, and they're not interested in making the conversion. If it's under $15,000, they have no choice because it is a mandate to do that. So I think it's reasonable, standard, customary, normal for that retailer, once they're given the denial, that they feel that their fuel station should be exempt, that they have no choice at that point in time, that they have to incur the expense up to $15,000 to get that fuel center converted, and they should be given at least 90 additional days to be in compliance with that. So for that reason, I ask my colleagues to please vote green on this amendment. Thank you.
Thank you, Senator Raybold. Senator Halloran, you're recognized to speak.
Well, I appreciate Senator Raymond's concern, but the amendment that she's suggesting here also presumes that an application for a waiver will be denied. The language of section 6 on page 4 of the amendment, line 18, states that the director shall issue an order that waives the requirement. The language says that if a retailer is eligible for a waiver, they get the waiver. Senator Rabel's amendment proposes to remove the language in the bill that allows the department and the fire marshal to evaluate the evidence of a retailer's qualifications for a waiver. Without the ability for the department to review the evidence presented and the expertise of the fire marshal to consult, the waiver process will be open to abuse by retailers who might submit a non-credible report from a paid consultant simply to avoid compliance. And again, I encourage a red light on AM 1378. It is not necessary.
Thank you, Senator Senator Halloran, and Senator Erdman, you're next.
Thank you, Mr. President. I see Senator Raybold's amendment, and I would assume that in some of these cases that these dispensers will dispense either 15 or E10, either one. And in some of those cases, if the tanks meet the requirements, all they have to do is change the sticker on the dispenser. And some people assume that those things you get gas from are a pump. They're not. The pump is in the tank. They're a dispenser. And so there'll be minimal cost to switch over on most of these gas stations, most of these service stations. And so what I believe her amendment is a solution looking for a problem. And so I will also be voting red on AM 1378. Thank you.
Thank you, Senator Erdman. Seeing no one else in the queue, Senator Raybold, you're recognized to close on the amendment.
Thank you, Mr. President. I've been involved in the business world for at least 36 or more years, if you count my work experience when I was 8 years old. And I deal with contracts on a daily basis for one of the largest corporations in our city of Lincoln. We operate in 3 states. This is pretty standard, customary, and normal language for any operator to have to get into compliance when you get a denial. Many retailers already have E10. They would not stop selling E10 because that's one of their biggest sellers, which means they would need to convert another one of their tanks and their pumps to their dispensers to be able to offer this. Right now, I can tell you that there is not a big demand for E15 or E30. We know that Iowa already went through this process, and it is not a high priority, high preference type of fuel in the state of Iowa. E10 is still their #1 seller. So yes, there's going to be some fuel centers out there. I'm not saying that they're going to be ours. I'm just saying that these small operators throughout our state of Nebraska are going to be forced to make a decision if they want to switch to get rid of their top seller E10 to go to E15. And they shouldn't have to be forced to do something like that. They shouldn't have to be forced to go through a very complicated process to get the waiver from the Department of Agriculture. If their tank is a single-walled tank, it's just way too old. It will not be able to handle any ethanol blend, let alone E10, because it's a single-walled tank. Most fuel centers are constructed with double-walled tanks that can take on any type of ethanol blend, but those are typically new fuel centers. And so I ask my colleagues, please vote on something that is a reasonable, standard, customary business language to allow those retailers to have the additional time they need to get into compliance. Thank you, Mr. President.
Thank you, Senator Raybold. Senators, the question is the adoption of AM 1378. All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
7 ayes, 27 nays on adoption of the amendment.
The amendment is not adopted. Mr. Clerk, for items.
Mr. President, next item, Senator Michaela Cavanaugh would move to amend with AM 1369.
Senator Michaela Cavanaugh, you're recognized to open on the amendment.
Well, thank you. Not sure what it is, so I'm going to go ahead and withdraw.
So ordered. Mr. Clerk, for items.
Mr. President, next item, Senator Hunt has AM 1380.
Senator Cavanaugh, it's our understanding you're authorized to act on that matter.
Yes, thank you, Mr. President, and I will withdraw AM 1380.
It is withdrawn. Mr. Clerk.
Senator Dorn, I have FA 68.
It is withdrawn.
In that case, Mr. President, Senator Brandt would move to amend with AM 1554.
Senator Brandt, you're recognized to open on the amendment.
Thank you, Mr. President. Good evening, colleagues. Tonight, I am happy to bring AM 1544, which is my bill, LB 116, regarding the Beginning Farmer Tax Credit Program. This legislation updates the Nebraska Next Gen program to assist beginning farmers and ranchers by modernizing the requirements to qualify for the program for the purpose of encouraging more beginning farmers and ranchers. LB 116 makes 3 changes to the eligibility requirements for the program. The first, it increases the maximum net worth for beginning farmers from $200,000 to $750,000. Number 2, it removes pensions and other retirement funds from the net worth calculation. And number 3, it removes the 10-acre minimum acreage requirement in the definition of a farm. Nebraska's Next Gen program, Beginning Farmer and Rancher program, began 22 years ago in 2001. Since that time, the program has helped 565 beginning farmers and ranchers and granted $16.2 million in tax credits. Over the last 5 years, the average number of applications per year have been 75, with the annual total tax credit of $1.3 million, which averages $5,200 in tax credits per year for each owner who leases to a beginning farmer. To qualify for the program, the beginning farmer or rancher must be a resident of Nebraska, have farmed and ranched for less than 10 of the last 15 years, provided the majority of the day-to-day physical labor and management, plan to farm or ranch full-time, and has farming or ranching experience or education, and has participated in an approved financial management course. Beginning farmers and ranchers who qualify for the program must sign a 3-year land rental lease rather than a year-to-year lease. They are also eligible for a $500 tax credit reimbursement for an approved financial management course, and they can apply for personal property tax exemptions. Under the fiscal note, the original fiscal note stated there could be an additional 10 or 11 million in tax credits, but on average, there have only been 1.3 million in tax credits annually from this program. To be safe, we are capping the program at $5 million annually, but I don't suspect it will get close to that number. Finally, LB 116 makes a few minor adjustments to the beginning farmer board and increases the net worth threshold to qualify for NIFA beginning farmers loan programs. Thank you, Senator Dorn, for allowing this bill to be added onto his priority bill. And with that, I would ask for your vote for AM 1544 as well as LB 562. Excuse me, 1554.
Thank you, Senator Brandt. Senator Erdman, you're recognized to speak.
Thank you, Mr. President. Good evening again. I was wondering if Senator Brandt will yield to a question, maybe two.
Senator Brandt, will you yield to a question?
Yes, I would.
Senator Brandt, you talk about having a personal property tax exemption. How much?
We know a little bit about that. My son Evan came home to farm about 4 years ago, and that was the only part of the program he qualified for. Basically, I think it will be up to $100,000 worth of equipment, and it amounts to about $1,500 a year for 3 years, if you have that whole amount. Now, if you have $20,000 worth of equipment, it's going to be much less than that.
So in other words, if you have 100,000, you'll be exempt on the whole 100,000. If you have 50, you'll be exempt on 50?
Yes. And if you have 200,000, you're only exempt on 100,000.
Okay. All right. Very good. Thank you. I noticed under your points you gave out, you passed out the information. It says increase the maximum net worth from 200,000 to 750. And then the next line says removes pensions and other retirement funds from the net worth calculation. So a beginning farmer who has a net worth of 750,000, excluding those things, in my opinion, may not be a beginning farmer. What do you say to that?
I think it would be unusual for a beginning farmer to have that kind of net worth. We met last summer, the Ag Committee, with all the stakeholders, and I know Senator Jacobson was there. On the pensions, what a lot of people don't realize is a lot of our young people in agriculture today will go work for another company before they come home to farm. Somebody like ADM, somebody like that, they might work 5 or 10 years for them or the co-op, and they can acquire a $50,000 or $100,000 in retirement. Under the current program, that counts against the $200,000, and it just doesn't leave much room for equipment or livestock, or in a lot of cases, land. So originally the bill was to go to $1 million, and we were in agreement that we could bring that down to $750,000.
Okay, so what you're saying then is if one qualifies for the beginning farmer, they can offer that tax credit to the landowner that they rent from. Is that correct?
That tax credit is an incentive for a landlord to lease to a beginning farmer as a carrot so he can compete against an existing farmer.
So what's the advantage for the beginning farmer?
The advantage for the beginning farmer, if he's going against an established farmer to rent a farm, he can go to that landlord and say, if you're willing to cash rent this to me, I can get you a 10% refundable state income tax credit. Or if you're willing to crop share this, you can get 15%. But this is subject to approval by the next gen board.
Okay, so let me understand this then. So you're removing the pension from the requirement that they made on the requirement from the net worth calculation, right?
Yes.
In the current program, that is included, correct?
Yes.
Okay, so you're removing that, and then you're increasing it from 200,000 to 750,000. And in your explanation to the last question, you said the reason they couldn't qualify is because their investments were counting against their net worth.
1 minute.
So if one removes their net worth from the pensions, the 200,000 may be an acceptable number for them to be able to get a beginning farmer opportunity. Would you agree?
It could be if the net worth is under $200,000. Yes.
That's a pretty good farm to have a 750,000 net worth starting out. excluding their pensions. Would you agree with that statement?
It is. If you look at the qualification, though, a beginning farmer can only have farmed 10 of the last 15 years. And I imagine somebody that's been around for 8 or 9 years, and I'm thinking a lot of our young farmers start out by custom farming, and they have quite a bit of iron in the yard, that can add up pretty quick.
Okay, I take a significant, it's pretty significant to have 750 net worth.
That's your time, Senator. Thank you, Senator Brandt and Erdman. Senator Jacobson, you're recognized to speak.
Thank you, Mr. President. I guess I have two comments. I'm going to have a question for Senator Brandt if he would yield to a question. But first, I guess I'd like to respond to Senator Erdman's concerns about the $750,000 net worth. I would tell you that one of the real issues, and we've talked about this a little bit when we talk about property taxes and the factory that we're talking about with farmland. I can tell you in Clay County, as recently as probably 2 years ago, maybe 2.5 years ago, we saw farmland probably get down in that $8,000, $8,500 an acre range. And since that time, over the last 2 or 3 years, we've seen that pop up to $12,000, $13,000 an acre, just because of a lot of outside investor pressure and other issues that are out there. So if you look at that, if you had a quarter section of land, it went up $650,000 in value. Okay, so if you're a young farmer who bought this quarter, you may be highly leveraged on the quarter, but you saw a big value increase, which of course you're going to pay higher property taxes on, but it also moves your net worth up. Now that net worth isn't going to be realized until you sell the land, pay the taxes and everything else. But when you look at what's happened to equipment values over that same time frame, and so at 200,000, what you're finding with a lot of these young farmers is a lot of them have $199,000 net worth, and they play a lot of games and a lot of gymnastics to get there. And so what this is doing, and you look in other states, that usually is somewhere sitting right at $1 million. And so I don't think that that's too high a number for a beginning farmer when you consider the kind of asset base that it takes to get started. That's what makes beginning farming and ranching so difficult, is because this industry is so incredibly capital intensive. So I would make that point. Senator Brandt, I would have a couple of questions for you if you would mind yielding.
Senator Brandt, will you yield to some questions?
Yes, I would.
Senator Brandt, I just want to talk a little bit about the fiscal note on this, because you're saying that we're going to cap this at $5 million per year, but historically the program's been closer to what, about a 1.2 million. What do you believe that $5 million is a real number, or could that number be lower?
The fiscal note actually was 10 to 11. No, nobody thinks that's a real number. I don't think there's enough beginning farmers in the state to get it that high. The most the program has ever used is 1.3 million. And I guess as a concession, we just put a cap in there at $5 million. I mean, I'm trying to see here.
How about 1.5 million?
What about 1.5 million?
How about we move that number from 5 million to 1.5 million?
I think you're going to have some expansion because they have a number of beginning farmers that don't qualify today because they're over that 200,000. And I don't think we know exactly what that number is going to be.
I guess my concern is I think if we could cap it at $5 million a year, that's what the fiscal note's going to be. And I would probably like to see that number, maybe at least half that number, and then we will look at adjustments maybe down the road.
I wouldn't be opposed to half that number.
Would you look at that as an amendment, perhaps?
Perhaps. Yes.
Take your time. All right. Thank you. Thank you, Mr. President.
Thank you, Senator Jacobson. Senator Linehan, you're recognized to speak.
Thank you, Mr. President. And I know Senator Dorn has worked very, very hard on this bill, and I've been a co-sponsor of the ethanol bill, and I'm absolutely supportive. I am concerned about this amendment of Senator Brandt's, and I will tell you why. And I did sign off on letting the Agriculture Committee have this tax credit, which in hindsight was not not because anybody's done anything wrong, but what we do in the Revenue Committee, what we've been doing all week, what we will do now until the end is judge all the tax credits, all the tax cuts, all of it together. And we will judge, as Senator Clemens said today, went through the budget and found another 15 million. So we are at that part, that time and space in the legislature where everything's got to add up. So I don't see how we can get, I mean, there are people walking away from things that work right now with less than $5 million fiscal note. So I don't know how we can accept a $5 million fiscal note. So I guess I'm saying, I know everybody wants to go home, but this, I don't know how we fix it, but this can't jump ahead of everything else because it's not coming from the Revenue Committee. Thank you, Mr. President.
Thank you, Senator Linehan. Senator Brandt, you're recognized to speak.
I think your concerns are well-founded, except that this program has never been capped. The most this program has ever used is 1.3 million. We got this fiscal note and we all about fell out of our chairs. And I think everybody recognizes that's a non-real fiscal note. And so we put the $5 million cap in there on a program that's going to use maybe 1.3 or $2 million. We won't know until the new criteria go into effect. I did hand out a sheet that compares our current program to Iowa. Iowa's cap is $12 million a year. Their net worth is $833,000. It's a little different. They give 5% on cash rents and 15% on share. But other than that, it's a very similar program to Nebraska's program. I guess the fiscal note will be produced after this passes. And, we'll work with the fiscal office to see if we can clean this up a little bit.
Thank you, Senator Brandt. Senator Erdman, you're recognized to speak.
Thank you, Mr. President. I appreciate the conversation. I also appreciated what Senator Linehan had to say, and also Senator Jacobson offering an amendment on the amount. So, Senator Brandt, if you would yield to the question, I may have a couple more.
Senator Brandt, will you yield to some questions?
Certainly.
Senator Brandt, I heard you say that they've used about 1.5 million in tax credits. Is that correct?
1.3.
1.3. Okay. So do you know how many farmers, Benningham farmers that were in that group?
Yeah. We had 75. Over the last 5 years, we averaged 75 farmers with an annual total tax credit of 1.3 million, which averaged 5,200 in tax credits per year for each owner who leases to a beginning farmer.
Okay, so according to the fiscal note at 10 million, that would be a substantial, significant increase in beginning farmers. Is there any way to have an opinion about how many people have been left out by the lower $200,000 maximum or minimum?
I can remember from our discussions last summer, at the most, maybe you would double that number is what they were thinking. We did have a producer in there who was pretty upset because his son never qualified with the committee because he was just over that amount.
Okay. All right. So considering Senator Jacobson's request, would we make the wrong assumption if we assume there may be an amendment coming up the next time this bill is read?
We would have to pull it back from final.
I understand that. Is that a yes or a no?
On my part, it could be a yes, but I think we work with the fiscal office to see if the fiscal office redoes the fiscal note and we come in high, absolutely. But I mean, if the fiscal office comes in at 2 million or something like that, do we still need to do that?
I understand. But I think 10 is exorbitant. But we all know how the fiscal analysts do these reports. I understand that. Thank you for your help.
All right.
Thank you, Senator Erdman. Senator Raybold, you're recognized to speak.
I actually stand in support of this because the Ag Committee reviewed this. We saw what Iowa's doing and offering to their young farmers, and I think we know it's so challenging for young farmers to get started. They have no equity built up in anything, not even in the land, so that it makes it even more challenging for them to go out and get any type of loan. So this seems like a good program, and it's also an incentive to someone to actually lease or rent out their land. And I want to remind everybody that the vote on the Ag Committee was 7-1. It would have been 8-0, but I wasn't at the meeting, so I would have voted in support of this as well if I were in attendance. So the Ag Committee did review it, and they supported it. So I don't know how to deal with this predicament because Senator Brandt didn't come up with the fiscal note. That's something that the analysts provided to the committee, but we felt it was a good investment in our young farmers and to keep our young farmers in the business of agriculture. So thank you, Mr. President.
Thank you, Senator Raybold. Senator Slama, you're recognized to speak.
Thank you, Mr. President. I rise in support of Senator Brandt's amendment. There seems to be some activity towards the front, so I just wanted to take some time to talk about the importance of supporting our young farmers so that we can get a potential compromise amendment on the board to get this very important amendment and this very important bill across the finish line. Our young farmers face an uphill battle in getting involved in agriculture. They face valuations that are going through the roof because investors, corporate agriculture is running up prices in bidding wars on land. And that's leading to ag land valuations for all of the neighbors around those pieces of land to go up as well. And when those valuations go up, on paper, our farmers look wealthier, they're not, and their taxes go up. And they're asked to pay bills that their farm income doesn't reflect. I mean, property taxes are really just you paying the government rent on your land. And with Nebraska's current ag land valuation system, we're putting farmers, especially young farmers, at such a market disadvantage compared to their counterparts with potentially deeper pockets. And I'm going to read through now just some key findings from the National Young Farmer Survey, which was conducted by, the National Young Farmers Collection. Oh, that's wonderful. And the report is entitled Building a Future with Farmers 2022, Results and Recommendations from the National Young Farmer Survey. Now, just a few key takeaways from this is finding affordable land to buy is the top challenge for young farmers. And that's because you're either planning to inherit that land from your family upon your family member's passing, or you're stuck trying to get into this business yourself. Either way, you're stuck from the outside looking in on this business. Purchasing affordable land is even more challenging for farmers of color. 58% of all young farmers named finding affordable land to buy as very or extremely challenging, and 65% of farmers of color ranked finding affordable land to buy as very or extremely challenging, including 68% of Indigenous respondents and 66% of Black respondents. Over half of all respondents, 54%, and 75% of Black farmers said that they currently need more access to land, whether to buy or lease. Now, this is a national survey, but it really gets to a trend we're seeing not only in Nebraska, but nationwide when it comes to ag land, in that investors, corporations are getting into bidding wars, bidding up land, and pricing young farmers out of the market to where there may be more opportunities for a farmer to rent land from the larger entity or from the investor, but not necessarily to own that land themselves. So they're never really building that equity themselves and building that wealth, building that ownership in the business themselves. And if you're renting your land instead of buying, you're not necessarily getting the same amount of buy-in. You're dependent on the good graces of your landlord. And that comes to upkeep of certain equipment as well. So you could be dependent on your landlord. Thank you, Mr. President. Landlord for things like pivot upkeep, and you're also stuck behind the 8 ball in purchasing equipment because you don't necessarily have the land that you can have as collateral for when you're buying that ag equipment. So this program is critically important to increasing access for our young farmers. So I'm proud to stand in support of this amendment and in support of Senator Dorn's overall bill. Thank you, Mr. President.
Thank you, Senator Slama. Senator,
Yes, sir.
Mr. Clerk, for an item.
Mr. President, Senator Linehan would move to amend with floor amendment 108.
Senator Linehan, you're recognized to open.
Thank you, Mr. President, and I'm sorry, colleagues. This will be really quick, I think. Senator Brandt, I didn't give him a heads up, so I'm going to ask Senator Brandt a question.
Senator Brandt, will you yield to a question?
This gets really down in the weeds, but I think what Senator Brandt said is that this program is only used 1.3 million on average. Senator Brandt, is that right?
That would be correct.
So capping it at 2 million, we give another $700,000. And it doesn't, when we get to this point, if we cap a program, my experience is, for the most part, there's few exceptions, if we cap a tax credit, that's what the fiscal note says.
Yes.
So if we cap it at 5 million, the fiscal note will say 5 million, when we both know that it's highly unlikely we'll ever get to 5 million, at least early on.
I would agree with that.
So if we cap it at 2 million in this amendment, and then next year, if we hit that, whenever we hit that, we can increase it.
I think that's a really good idea. I would encourage everybody to vote for Floor Amendment 108, AM 1554, and LB 562.
I agree, 100%. Thank you very much, Ms. Senator Brandt.
Thank you, Senator Linehan and Senator Brandt. Senator Brandt, you're recognized to speak. And wave. Senator Linehan, you're recognized to close on the floor amendment. Wave. Members, the question is the adoption of FA 108. All those in favor, vote aye. All those opposed, nay. Record, Mr. Clerk.
38 ayes, no nays on adoption of the floor amendment.
The amendment is adopted. Senator Brandt, you're recognized to close on AM 1554 and wave. Members, the question is the adoption of AM 1554. All those in favor, vote aye. All those opposed, vote nay. Record, Mr. Clerk.
38 ayes, no nays on adoption of the amendment.
The amendment is adopted. Mr. Clerk, for an item.
Mr. President, Senator Vargas would move to amend the bill with AM 1563.
Senator Vargas, you're recognized to open on the amendment.
Good evening, colleagues. I am here to introduce Amendment 1563, which would add my bill LB 740 to LB 562. First, I want to thank Senator Dorn for allowing me the opportunity to bring this important piece of legislation to the floor. I'd also like to thank Chairman Halloran and the members of the Ag Committee for voting this bill out unanimously 8-0 with no fiscal note. Special thanks to Center for Rural Affairs, the Grocers Industry, Hospitality Association, the Platt Institute, Americans for Prosperity, and Nebraska Farmers Union for the support on this bill. This bill would standardize and streamline the permitting and inspection processes for food trucks here in Nebraska. I have already made a commitment to Senator Kauth. We will bring food trucks here at some point so that we can enjoy some of the local food trucks. Food trucks have been recognized by food writers and world-renowned chefs. We have some of the best restaurants and chefs in the region and the country right here in Nebraska. My district is particularly home to some of the state's most successful breweries, distilleries, and a lot of food trucks. Several years ago, I was approached by food truck owners about the complications they face while trying to operate their businesses, which is the impetus for this legislation. This legislation is about reducing overregulation, promoting entrepreneurship, and maintaining dining choices for consumers. These issues arise from a current regulatory framework, which is a bit of a patchwork of regulations from county, municipal, and state governments that make it difficult, costly, for food truck owners to navigate and comply, which is why I brought LB 740, which will take a significant step towards finding solutions to maintain health, safety, respect local control, and recognize the rights of the food industry. Right now, local municipalities and our state government have this patchwork of regulations. It's difficult and costly for entrepreneurs to navigate and become profitable. These same food truck operators often operate in multiple cities, so these differences greatly impact their ability to conduct business and remain profitable. So for example, a permit to operate in Lincoln or Bellevue can be hundreds of dollars more expensive than it would be in Omaha. The cost to operate, coupled with having to chase down the different permitting rules, can become a hurdle for these small business owners. Currently, there are about 620 different versions of regulations. That's correct. Different regulations, 620 of them applicable to food truck operators in the state of Nebraska across all the counties and municipalities. My office has been working with food truck owners for the last several years. It saddens me that when we first introduced an iteration of this bill, an overwhelming majority of them actually closed down because it was so burdensome. So this is in retribution for them, paving the way for the new food truck operators trying to start a business and make this possible in our state. And I know we believe in supporting small business owners, as we've just been discussing this today. In our hearing, we discussed overarching goals with this legislation. We heard from the stakeholders about the reforms necessary. You have a one-pager that documents all these things and why this is a growing sector, why it's about consumer choice, reducing these regulations. I want to say thank you to everyone who's been working on this legislation with me for several years. LB 740 is a straightforward way to make sure that we're expanding this industry. And I want to thank all the stakeholders for their work. Again, please support Amendment 1563, unanimous out of committee, no opposition testimony, so we can move on and get home tonight. Thank you.
Thank you, Senator Vargas. Senator Raybold, you're recognized to speak.
I stand in support of this amendment that Senator Vargas has been working on for many, many years. It passed out of the committee. I know you mentioned that 8-0 in Agriculture Committee. We know that food trucks are very much in demand and requests. I just think all across our state with rodeos, with county fairs, state fairs, all the sports activity, they're really growing in popularity. And I just want to let you know, all the proponents that supported this bill are just a very diverse, really interesting group of people. You know, Americans for Prosperity, Nebraska's Farmers Union, Center for Rural Affairs, of course, the Nebraska Grocery Industry Association, the Hospitality Association, Friends of Public Health, and the Platt Institute, as well as the really brave pioneers in the food truck industry. It's something that we've struggled with in the city of Lincoln to really work with our Department of Public Health to make sure that we can make them more accessible and available to the consumers that really appreciate the fine cuisine that they present. And oftentimes they're some of the best of Nebraska cuisine. So I encourage my colleagues to please vote in support of this amendment.
Thank you, Senator Raybold. Senator Erdman, you're recognized to speak.
Thank you, Mr. President. This is the first I've seen of this bill, so I'm trying to get my hands around it. I wonder if Senator Vargas yield a question or two.
Senator Vargas, will you yield to some questions?
Yes, happy to.
Senator Vargas, have you seen the fiscal note that was on 740?
Yes, if I'm remembering the right fiscal note, yes.
Okay. Can you explain, if you can, why there would be a $12,000 revenue loss or cost to inspect these food trucks? Don't we already have food trucks?
So, yes. So my understanding is the reason why there was a $12,000 revenue loss, we changed the definition in regards to some of the food truck language. And as a result of that, it basically exempted and lowered the cost of the fees to the state. So it would be $12,000 less to this cash fund. But that's a negligible amount. It really didn't, that's their estimate based off of this. It'd be about $12,000 in revenue loss.
So does that seem reasonable to you?
Reasonable? What standard?
Well, I mean, it's kind of peculiar if you already have these food trucks. So what you're doing is you're allowing them to go from one jurisdiction to another. Is that correct? No. The bill does two primary things. One, it allows for interlocal agreements between certain municipalities. So it creates the framework for them to be able to do this. And then second, it creates a one-stop shop where all the different regulations would be housed for cities across the state so that food truck owners can then look at the regulations in one place rather than making it very burdensome for every single community to be reaching out to them independently and making it harder on them. Okay, so if I have a food truck and I'm in one municipality and I go to another, I have to have another inspection?
That actually is still state law. This is not touching that. So different cities, different municipalities, it depends on if you are, let's say, Douglas or Lancaster or Sarpy, or versus some other cities outside of those. You're either going to fall under the standard of those larger counties, or you're going to fall under the standard of the Department of Ag. We have not touched that. That still exists, and that's just current law. So we're not touching that.
So the last part of the fiscal note says, the estimated reduction in the revenue as this will shift some of the establishments defined by the mobile food establishments to the mobile food units, which will cause a shift in the fees levied. So there's going to be less, you're going to charge less of a fee?
In one of the language changes, we will be slightly charging less for one of the fees, and that's the revenue that would be lost would be about $12,000 to this cash fund.
Okay, thank you.
Thank you, Senator. Senator Slama, you're recognized to speak.
Thank you, Mr. President. I rise in strong support of Senator Vargas's amendment. If I'm remembering right, he brought this bill in my freshman year when I was serving on that committee. And I was very confused as to why it didn't pass that year. And I'm grateful to Senator Vargas for keeping up the good fight and fighting against unnecessary regulation to allow our food truck industry to thrive in the state of Nebraska. So with that, I'd encourage everyone to greenlight vote Senator Vargas's amendment.
Thank you, Senator Slama. Senator Brandt, you're recognized to speak.
Thank you, Mr. President. I stand in strong support of AM 1563. Would Senator Vargas answer a question?
Senator Vargas, will you yield to a question?
Absolutely.
Senator Vargas, like Senator Slama, when I served on the Ag Committee, I remember several food truck bills, and specifically yours and Senator Aguilar. And did Senator Aguilar have an interim study on this this summer and work with you on this?
Yes. And so a big thank you to Senator Aguilar for their work, the Center for Rural Affairs and many others that worked on interim study to inform many of the things that we are doing in this. And yeah.
So this bill addresses any concerns that he had with his food trucks. Is that correct?
Yes, that is what we worked on.
All right. Thank you, Senator Vargas.
Thank you, Senators. Seeing no one else in the queue, Senator Vargas, you're recognized to close and waive. Members, the question is the adoption of AM 1563. All those in favor, vote aye. All those opposed, vote nay. Record, Mr. Clerk.
40 yeas, no nays on adoption of the amendment.
The amendment is adopted. Senator Ballard, you're recognized for a motion.
Mr. President, I move that LB 562 be advanced to ENR for engrossing.
Members, you have heard the motion. All those in favor say aye. Those opposed, nay. It is advanced. Mr. Clerk.
Mr. President, new LR 137 from Senator Bostar. That'll be referred to the executive board. Name add, Senator Frederickson, name added to LB 705. Finally, Mr. President, priority motion. Senator Ballard would move to adjourn the body until Wednesday, May 10th, 2023 at 9:00 a.m.
Senators, you've heard the motion. All those in favor say aye. All those opposed, nay. We are adjourned.